Yes.
My lord, may I be permitted to mention, my lord, one urgent matter. Urgency is that the petitioner before your lordship has made an application for new passport for going to Hajj, which is going to commence within 2 months thereafter.
Use microphone.
She has applied for a new passport for going to Hajj, which is going to commence within 2 months. My lord, at the time of verification, the authority has refused to accept the AP, which has petitioner got in the downloaded form from the website. The physical copy due to SIR has not reached to her. There is a provision for considering the same with alternative documents. They have refused to accept the alternative documents.
What is the alternative document?
Alternative documents, the ration card and the deed and other documents.
So, what you want?
The urgency is that there is a procedure. It will take some time that I have to go to abroad within 2 months. Which is
when you are going to the abroad?
Within 2 months.
2 months. Okay.
If your lordship give some preference, I have
filed the writ petition.
Yes, my lord, I have filed.
It is not in list.
No, yesterday I have filed. 25th they have refused. 25th they have refused.
25th of March, February.
February, my lord.
They refused.
Yes, my lord. I have mentioned it in the presentation form to matter to be appear on 12th. If your lordship
given the date of 12th March.
12th March.
12th March.
My lord, lordship, may I be permitted to mention two matters, lordship? One for inclusion as
today is not the mentioning day. Yes, call the list.
Only one instance. Your lordship, item number 47 of today's list. Lord, this matter, Lord, appeared on 27 as item number 10. Lord, state prayed for an adjournment. Lord, it was under the impression that the matter would retain its position in the list. But Lord, it has gone down. Lord, there is some urgency in the matter.
What can be done when the matter is in the place? Your persons are taking the time. So
the state has taken the time. I am
you have objected for.
I had objected.
Sorry.
I'm mentioning for non-prosecution. Any time at the day, my lord. Otherwise, my petition will become infructuous.
You do one thing. You take the diary from my court officer. You give the
I bow down to your lordship. But any time,
you know what is the situation of this court?
I know, my lord.
Then,
well, deepest of respect, my lord, because 10th, my lord, the tender would open, my lord. I am being blacklisted. Not my deed.
Blacklisted. How your case can be considered in the tender process?
Well, that is why I have come before your lordship, my lord. That is why, my lord, 27, my lord, I pressed the writ petition. My lord, state prayed for an adjournment, and my lord, the matter has gone down the list, my lord. That is my predicament, my lord. Kindly appreciates. Any time your lordship chooses.
What is the number of your case?
My lord, item 47, my lord.
Item 47 is let it wait. Let us see.
Does not, my lord,
how far the court can go today?
Let us see. At 3 p.m. my lord, kindly, my lord.
See to that.
Your lordship for non-prosecution.
No inclusion, nothing. Yes. Your lordship for non-prosecution. Call the list. Andaman matter.
You yesterday mentioned two matters, my lord.
My lord, yesterday mentioned.
9 matter, my lord. 2009 motion.
Yes, who is for the petitioner?
My lord, I'm appealing. My lord, I'm for the respondent, my lord.
Yes.
This petition is basically.
Anybody is appearing for the respondent?
My lord, I'm appearing, my lord, through virtual mode, my lord.
Okay.
Mr. Rakesh is there. Well, this is basically on account of inaction on the part of the town planner in not considering my pending application for grant of approval, my lord. I'll just indicate the sequence of events, then I'll take my lord to the provisions of law, my lord. My lord, what had happened, I had made an application which is appearing at page 23, if my lord would kindly see.
Page
23, my lord.
Yes.
Page 20. My lord, may kindly take a note of the date, which is on the sealed on top of it. It's 16/12/2019. I make this application. Now, my lord, may kindly turn over to page number 25. It is forwarded to the town and country planner. My lord is aware that now, after coming into force of the town and country planning regulation in Andaman Nicobar Islands, the planning permission and the building plan is sanctioned by the town planning department, not by the municipal authorities. So, page 25, it's forwarded, my lord, to the town planning department with containing that all the details have been furnished by me, my lord. Now, my lord, may kindly now turn over to page 47. My lord, is a document where my application is processed by the town planning department. 47. Got it, my lord?
Yes.
My lord, may I kindly turn over to page number 48. If my lord would see,
Hey, fan बंद करो. बंद करो. Yes.
everything is marked as permitted at page 48. If my lord would kindly see, except at serial number 5, I'll come to that. That's the issue, which is basically the subject matter of contention. Width of the road 1.7. Rest all, if my lord would see page 48 and 49, everything is permitted.
Okay.
Now, what happens thereafter, my lord, may I kindly come out to page 26. The town planning department, my lord, they issue me a show cause notice. Page 26, my lord.
Yes.
With reference to your application number nil dated so-and-so received through PBMC Port Blair White application number so-and-so for undertaking development of so-and-so at survey number so-and-so, I am to inform you that the sanction could not be granted for the following grounds. The applicant Biswajit Biswas and 4 others resident of Premnagar have submitted a proposal for construction of triple-story residential building on the plot under survey number so-and-so of Janglighat village, measuring a total area of 1349 square meters through the authorized officer, Secretary PBMC. The proposal was discussed in the meeting held under the chairmanship of Chairman PBPDA on 3/3/2020. As the said plot is approachable only by 1.7 meters width footpath, and it would be difficult for the movement of vehicle for firefighting and other services to the plot during the emergency. It was therefore decided in the meeting to refuse the permission allowing the development of a triple-story building. You are hereby given an opportunity to show cause within 15 days from the date of receipt of this letter. So, my lord, a show cause is issued to me. Now, if my lord may kindly turn over to page 27, my lord.
27.
27, my lord.
Yes.
The typed copy is at page 28.
Yes.
27 is not clear. This show cause is forwarded by the municipal authorities to me, my lord. So what I do, my lord, at page 28, I reply by a letter dated 7/7/2020 appearing at page 28, my lord.
Yes.
Now I submit a revised plan and I say that the width of the road, my lord, there is reduced at that relevant point of time. Now the encroachment at this particular moment, even that is removed. The path, my lord, at that relevant point of time was encroached by the adjacent plot holders. So if the authorities have not removed those encroachments, why should I suffer for that? So I say, though there are encroachments, and I submit my revised plan, my lord. My lord, this revised plan which is pending, my lord, there has been in fact a litigation also, my lord, between me and my relatives with respect to the subject land. They approached the Honorable High Court for demolition and other things, my lord. My lord, may kindly come to page 39.
Where you mention in the so cause reply with the side plot holders of
Last paragraph, my lord. Page 28. Approach road could not be widened further due to encroachment in government land bearing survey number 119/P by Srimati Ruma Bose. Got it, my lord? Now, my lord, may kindly come to page 39, my lord. This lady, my lord, who is a relative of mine, she has been creating hindrances against me, my lord. In fact, there was a civil suit where she had challenged the gift, which is not the subject matter here, but I'll just appraise. She had challenged the gift deed, which was executed in my favor and the other relatives. A suit was decreed in our favor, but subsequently in the first appeal by the learned district judge, the decree and judgment has been reversed and the suit has been dismissed, my lord. So she has no stake as far as the land is concerned. If my lord may kindly come to page 39, this is an order dated 2nd March 2020, my lord. Relevant would be page 40. It is further made clear that the application for sanction of plans submitted by the private respondent should also be processed, and the authority shall show clarity and promptly addressing the issue rather than keeping the same in abeyance. My lord, after the show cause is issued, I reply to the show cause. I submit my revised plan, and in spite of a specific order of a learned single judge.
So you are the private respondent in this page 39.
39, my lord, private respondent. Now, my lord, the Lieutenant Governor, my lord, the Honorable Lieutenant Governor, my lord, he issues, before that, my lord, I'll just come to the relevant provisions of the Town and Country Planning Regulation, my lord. My lord, relevant would be section 12, my lord. Every person or body, including department, government, desiring to obtain permission referred to in subsection 2 of section 11 shall make an application in writing to the town planner in such form and containing such particulars in respect of development to which the application relates as may be prescribed. Every application under subsection 1 shall be accompanied by such fees as may be prescribed. That I have paid, my lord. Provided that no such fee shall be necessary in case of an application made by department of the government or by the administration. On receipt of an application for permission under subsection 1, the town planner shall issue an acknowledgement of receipt of such application, and after making such inquiry as he considers necessary, shall by order in writing either grant the permission subject to such conditions, if any, as may be specified in the order, or refuse to grant such permission. Provided that before making an order refusing such permission, the applicant shall give reasonable opportunity to show cause why the permission should not be refused. Where a permission is refused, the ground of such refusal shall be recorded in writing and communicated to the applicant in the manner prescribed. If the town planner does not communicate his order to the applicant within 6 months from the date of acknowledgement of receipt of the application under subsection 1, such permission shall be deemed to have been granted to the applicant on the expiry of the said period of 6 months. One of my case, my lord, is a deemed sanction. But I will not press even that. What I am seeking, my lord, from your honor, the Lieutenant Governor,
What has done now?
the Lieutenant Governor, he says that no fruitful purpose would be served in remanding the matter back to the town planner for consideration of the pending application.
So the so-called reply which you have given,
My lord.
in this you have already specifically taken the stand that the site plot holder or private respondent, whatever.
At that relevant. Now they have, even that encroachment is removed now. Removed, my lord.
Okay.
So what my respectful submission, my lord, would be that admittedly there's a pending application, a revised plan before the town planning matter. Let them consider that application.
When you file the revised?
Revised that same date, my lord, on page 28, on 2020, it's pending since then. The application, my lord, it's neither rejected. They have followed regulation 12 up till the show cause. But after the show cause, there is neither a rejection nor a approval. In fact,
what the governor has passed an order?
He says, my lord,
Sent to the governor.
he says, my lord, no fruitful purpose.
Why the second appeal? Against which order you prefer the appeal before the governor?
My lord, in the intervening period, my lord, the at the instance of the my relative Roma Bose, the municipal authorities had passed an order of demolition. So it was against that order of demolition I had gone. If my lord may kindly come to page 141. And before that would be, my lord, page 141st, my lord. 140, paragraph 5.
Yes.
As regards contention A, the record shows that although the appellant claimed to have submitted a reply dated 7/7/20 to the show cause notice, the said reply was not received by PBMC. My lord, why should I give the reply to the PBMC? The show cause was by the town planner. Though whom the show cause notice was, instead it was allegedly submitted directly to town and country planning unit, which is neither the prescribed nor notified channel of communication. Even assuming such a submission was made, the appellant failed to follow up the same and also failed to appear in subsequent personal hearings scheduled by municipal council. The show cause is by the town planner. Why should I appear before the municipal council, my lord?
Whether the town planner is the authority to hear?
Yes.
Under which provision?
That is what I had chosen. Regulation 12.
Every person. To the town planner.
Town plan, my lord. Now, after the coming into force of the town planning regulation, the sanctioning authority is not the municipal council, it is the town planning department. It says, failed to appear before the subsequent personal hearing scheduled by the municipal council by letter dated so and so. The appellant's passive conduct is in not ensuring formal communication, and the non-participant in the hearing undermines their case for procedural compliance. Now, my lord, may kindly come to page 141, last paragraph. Regarding contention F, the prayer for remand cannot be entertained in absence of any revised building plan or supporting document reflecting changed circumstances. The appellant cannot be permitted to benefit from a situation created by his own omission. I don't understand what is my omission, my lord. I reply to the show cause. They keep it with them in the drawer. They don't decide it.
So how this telling that the municipal council and the planning authorities have repeatedly offered opportunity?
Let them show, my lord, the planning authority after my reply to the show cause. After my reply to the show cause, if they have called me for a hearing, the town planner, even on an occasion, I'll not press this application, my lord.
Where is the appellate authority order?
4th February, which was received, my lord. We have stated on 24th of February we received it, my lord.
Where is that? Page
Which one, my lord?
128, municipal authority. Appellate authority.
139.
139.
LT's order?
139 is the with regard to the governor. The
Yes.
second appellate authority.
Yes, my lord. My lord is asking.
First appellate authority.
The first appellate authority would be 78, my lord.
78.
My lord. This is very interesting, and if my lord would see the first appellate authorities only whereas, and says it, so it is no reasoning,
Who is the
nothing.
first appellate authority?
Deputy Commissioner,
Page 78.
78, my lord.
Ach.
My lord was appearing for the municipal for substantial period of time.
No, that's why I thought it is reviewed or something else.
If my lord would see page 78, only narration of facts, no reasons, no findings. 78, 79, only narration of facts. And page 80, therefore it is rejected. I say my application is pending, examine it in terms of the rules. If it can be granted, granted, otherwise it won't be granted.
Yes. Yes, Mr. Kumar.
Yes, my lord. May I please, my lord?
Yes, yes.
My lord, the municipal authority issued stay in the year 2020, my lord. And they have been restrained to stop the work, but they have continued with the work. Thereafter, my lord, the provisional and demolition order has been passed. In the meantime, the Ruma Post approached before the High Court for execution of the demolition order. And subsequently, based on that order, opportunities of PBMC has been given. My lord, till today, my lord, though they say that revised building plan is submitted and it is pending before the PBMC, no such building plan is pending before PBMC, my lord.
PBMC, town planner.
No, town planning. Kindly come to the page
28.
Yes,
28. Kindly come to the page 28 because initially he has made an application on page 23
yes, my lord.
to the country town this authority.
Yes, my lord.
And then they have issued the so-called notice.
Yes, my lord.
Correct.
Yes, my lord.
And he has submitted the reply.
Yes,
Now,
my lord.
Submitted reply page 28.
Yes, my lord.
28 stated that now due to the expansion of family, we are unable to delay the construction new building. Therefore, request you to kindly approve the revised proposal.
Yes, my lord.
So what is the reply of this so-called reply? So-called notice.
Lord, the town planner has only communicated wide, my lord, 30th June 2020. If my lord will come to page number 42.
42.
Yes, my lord.
Yes.
Lord, he has replied to the Secretary Municipal Council. My lord, the second paragraph may kindly see me. In this category, informed that as applied for planning permission for construction double on the plot number so and so, Jungli had been missing a total area of so and so. The committee refused to accord permission for the proposal according to the show cause was issued by this wide office number so and so authorized officer. Lord, then they have refused. We being an authority, my lord, we have communicated that the show
Yes.
cause.
This
Yes.
has been given by the town and county
Town
planner
planner to the Secretary PBMC.
PBMC. But what about the so-called notice? Kindly come to the page so-called notice issued by the
26, my lord.
page 26.
Yes, my lord.
Page 26. The so-called notice issued by the officer town town and country planner.
Yes, my lord.
Correct.
Yes, my lord.
And 28 is the reply. If the so-cause has been issued and the reply has been filed, then that is to be adjudicated.
My lord, as due respect, my lord, that is on 10 June 2020, my lord. And that 30th June, he has informed that the permission as accorded has been not granted. As such, the PVMC's procedure based on.
That is the Podla municipal. It has to be to Podla. Where is the hearing?
My lord, that town planning, my lord, is a APWD authority, my lord. I am appearing on behalf of the municipal council.
So it has been informed to you whether this.
My lord is saying in terms of the so-called whether any hearing was concluded and any order has been passed to that extent or not.
Yes,
That is my lord is scoring to that extent.
pending before the town and country plan. No. If the revised plan is pending before the town and country plan, no, and it has not been adjudicated, and you have based on the illegal demolition order.
Yes,
But
my lord. Because
the revised plan, and kindly come to the governor's or lieutenant governor's order. He is telling that the authority is not the authority, and the town and country planner is not the authority. How it can be?
my lord, the revised building plan has to be submitted before the municipal council, my lord, in terms of the building bylaws. He straight away submitted to the town planner. Rather,
Okay.
the town planner has issued a show cause. But
Hmm.
subsequently, my lord, the town planner has submitted on 30th June to the municipal secretary saying
Right.
that he's filed that plan what is proposed that has been not accorded permission. So
Correct.
as such, they issued a show cause.
No, that's why if the town and country planner has issued the so cause notice and he has submitted the so cause notice, if it is rejected, the hearing is to be given and it has to be informed to the petitioner. Where is the communication? Who is appearing for the PWD?
Otherwise, it's deemed approval otherwise.
Lord, I take instruction in this regard, my lord, but with regard to the PBMC, my lord, we don't have any record to show that, my lord, any revised planning. As my lord is right, when a show cause was used, there should be an hearing has to be done and order has to be passed.
Right.
Whether that has to be done or not, that, my lord, I take instruction on that part if subject to lord.
So for the present, I am staying the order of the governor authority and sending the matter to the circuit bench. You file, let you appear and the
Yes,
authority appear and take up a petition.
we will file our affidavit in the meantime.
Yes.
Yes.
He had served all of them.
The petitioner has filed the present application challenging affidavit of service filed by the petitioner be kept in the record. Challenging the order dated 10th of January 2020 passed by the Secretary Municipal Council, order dated 10th October 2024 passed by the Deputy Commissioner in the capacity as a first appellate authority, and the order dated 25th of November 2024 passed by the Secretary Municipal Council directing the demolition, and the order dated 4th of February 2026 passed by the Lieutenant Governor as a second appellate authority. The grievance of the petitioner in the present writ application that on 16th of December 2019, the petitioner has filed an application before the concerned authority for sanction of the building. On receipt of the said application, the municipal authorities have forwarded the same to the town and country planner by a letter dated 31st of January 2020. On receipt of the same, the town and country planner has issued a so cause notice to the petitioner on 10th of June 2020. In reply to the said so cause notice, the petitioner has submitted a so cause reply on 7th of July 2020, stating the fact that due to expansion of the family, the petitioner are unable to delay the construction of the new building. Therefore, he requested to approve the revised proposal in which the floor plan is changed from 2 BHK to 1 BHK each, and the approach road could not be winded further due to encroachment in government land bearing survey number by government land bearing survey number 119 by P by Srimati Roma Bose. The Petitioner has further drawn the attention of this court to the order passed by this court, passed by the coordinate bench of this court in WP number 080 of 2020, dated 2nd March 2020, filed by one Srimati Ruma Bose, wherein the petitioner is the private respondent. And while disposing of the said writ application, the coordinate bench of this court has made it clear that the application for sanction of the plan submitted by the private respondents within bracket petition herein shall also be proceeded, and the authority shall show alacrity and promptly addressing the issue rather than keeping the same in abeyance. Full stop. It is submitted by the land council for the petitioner that pending the revised plan before the town and country planner, the first appellate authority as well as the second appellate authority have proceeded with the appeal preferred by the petitioner and confirmed the order passed by the municipal council for demolition of the building of the petitioner. This court failed to appreciate full stop. This court has gone through the impugn order passed by the second appellate authority, that is the Lieutenant Governor, wherein he has noted that the petitioner has allegedly submitted the revised plan to the town and country planner unit, which is neither the prescribed nor notified channel of communication. Even assuming such submission was made, the appellants failed to follow up the same and also failed to appear in subsequent personal hearings scheduled by the municipal courts. Full stop. This court failed to appreciate the observation made by the second appellate authority. The so-called notice has been issued by the town and country planner of APWD Department of Andaman and Nicobar Administration. The petitioner has submitted the so-called reply, categorically informing that the revised plan is pending. If the town and country planner is not the authority to consider the revised plan, the same could have been remitted back to the Secretary Municipal Council for consideration. But instead of the same, the same was kept pending before the authority. Learned Counsel appearing for Mr. Rakesh Kumar, Learned Advocate appearing for the Andaman Nicobar Administration, submits that the town and country planner by a letter dated 30th June 2020 informed to the Secretary Municipal Council that the petitioners have applied for planning permission for construction of double-story residential building on the plot, and the competent authority has refused to accord permission for proposal, and accordingly so-called notice was issued by this office. But the said communication also does not reflect whether the town and country planner has taken any decision with regard to the proposed revised plan submitted by the petitioner, or whether the revised plan has been remitted back to the Port Blair Municipal Council for consideration. Full stop. Considering the Learned Counsel appearing for the administration submit that he is only having instruction to appear today on behalf of the Port Blair Municipal Council. He is not having further instruction from the town and country planner with regard to the revised plan submitted by the petitioner as mentioned in the so-called notice. Considering the above, this court find that this writ petition is to be disposed of only after exchange of affidavit. Thus, the respondents are directed to file their affidavit in opposition within 3 weeks. A reply, if any, they are to be filed within a week thereafter, within 2 weeks thereafter. Full stop. The impugn orders shall remain in state for a further period of 6 weeks from date. The department is directed to transmit the record of this case to the circuit bench at Port Blair as early as possible.
Oblige.
Oblige, my lord. Lord, may I permit to leave, my lord?
Yes.
Oblige.
My lord, I'm so sorry, my lord. I thought that this is some unlisted matter of Jalpaiguri bench, so I could not mention because there is no list of JPD. So it was being shown as JPD outside. The only thing is this is a matter pertaining to the principal court jurisdiction. 110 crores due from the state of West Bengal. Now Justice Sinha, Amrita Sinha passed an order giving the direction upon the respondents to form a neutral committee to assess my claim. Now, despite that order, they have passed an order saying that no neutral committee is required. Now, I am challenging in the nature of execution of the order, where Reed Court can execute its own order. Now, the difficulty is that I have received an assessment notice. 31st March is coming. That the 2015-2016 assessment has been reopened, saying that I worked.
What assessment?
Reopened that I have worked, but I have not shown any gain. Because I could not have shown because the amount is still pending.
Why this court?
Because group 9.
How this group 9?
Because there is no other option. The thing is that any day it was due to be returnable today, but I know the process kindly keeps it any day before 31st of March. Before 31st of March, so that it can be taken up. I'm not saying
23rd March. Yes, call the list.
But 23rd.
23rd is Monday.
23rd is Monday. Can it be on 25th at the top?
25th. 25th within 5 minutes.
Obliged.
Yes. कौन सा? No, the other the connected matters है ना 3 से उसको 2 1 is not there. Yes, what is the correction?
So the petitioner.
I'm for the petition.
What is the correction?
Your Lordship, in the 8th paragraph, the writ petition number has been wrongly typed. It is 9174.
9174.
9174.
Your Lordship,
The matter is listed as to be mentioned for correction of the order dated 18th February 2026. Full stop. It is submitted by the learned counsel for the parties that in paragraph 8, the WPA number has been wrongly inadvertently recorded as 6033 of 2024 instead of 9174 of 2024. In view of the above, in paragraph 8, the WPA number shall be read as 9174 of 2024 instead of 6033 of 2020. This order will be read with order dated census and so.
Another small submission. I have mentioned a similar matter yesterday. Writ petitioners acid attack survivors. It is not listed today. Acid attack survivors, similar writ petition. I have mentioned it yesterday. Your Lordship has asked for compensation. Your Lordship.
See, there is a date. You take the date. Whatever the mentioning list, I have already provided the date if the reason has been given. If no reason has been given, no date has been given. Yes.
I appear for the petition as well.
Yes, 3 affidavit completed. How many matters?
My lord, in 3, my lord, 3 and 4, my lord. 4, my lord, affidavits filed by respondent numbers 3 and 4, the contesting respondents. We have to file, my lord, petitioners have to file reply.
But in item numbers 3 and 4, my lord, 3 is completed.
No, affidavit in reply is awaited from the petitioner's end.
So 3 and 4.
Yes.
3 and 4, affidavit in opposition filed.
Yes.
There is no further
Filed by the, my lord, contesting respondent, because it is the state who has to take a stand.
And you want to file the reply.
I want to file my affidavit in reply.
Yes, record an order.
But only one correction. In 3 and 4, affidavits in opposition have been filed by state as well as the implementing agency, that is West Bengal Industrial Development Corporation. There are 2 affidavits in opposition in items 3 and 4.
So I'll file 2 affidavits in reply dealing with those 2 affidavits.
So who has filed?
My lord, respondent numbers 3 and 4 have filed oppositions.
No, 1 and 3. 1 and 3.
3 and 4.
3 and 4.
My lord, it would be 3 and 4 according to me, my lord. You should go to 3 and 4.
Respondent number 4, State of West Bengal.
3 is WBIDC.
3 is the WBIDC.
Yes, my lord.
Record an order. Item number 3 and 4. It is submitted that the respondents number 3 and 4 have filed their affidavit in opposition after serving the copy to the land council for the petition. Counsel for the petitioner prays for time to file reply. Let affidavit in reply be filed by Mr.
But 2 weeks. 2 weeks, my lord.
in 2 weeks. ठीक है? Date बाद में देगा. Now, yes. Then 5.
Item number 5, I appear for the petitioner. Only that WBIDC, that is the respondent number 3, has used the affidavit. State is yet to file the affidavit, subject to correction.
This word in item 5, 7, 8, 11 and 14. We are filing the Milord
8, 11 and 14.
14.
Yes.
Stated to 16.
So you
16.
16 also.
And 16.
16.
9, 10.
Milord, the affidavits are being filed today, Milord.
By the WBIDC.
No, both.
Both.
State's affidavit we are yet to receive.
I am also yet to receive, my lord.
State's
State
আজকে তো ফাইল হচ্ছে আজকে ফাইল করছি these are being filed today. Yes, in course of the day
The
वो तो दे
item
दो
number 5,
वो extra दे दो
7, 8, 11, 14 and 16.
right
Then counsel for the respondents number, same respondents. Respondent number
yes Milord, kindly Milord, I don't know whether the numbers will match state as well as WBIDC.
WBIDCL. WBIDCL.
WBIDC.
IDCL have filed their affidavit in opposition after serving the copy to the learned counsel for the petitioners.
Kindly not revert after serving because
Let the same be kept. You are serving the copy.
I'll serve it within a day or two.
Have filed the affidavit in opposition. Let the same be kept with the record. The
State will
petitioners
zero.
are at liberty to file affidavit in reply within 2 weeks after serving the copy to the learned counsel for the respondents.
Quite a bucket.
Yes, what about the other?
Milord, so far as 6, 9, 10, 12, 13 and 15 will give us some time to Milord file our opposition.
Yes, pleadings have not been exchanged there.
Item number 6,
6, 9, 12 and 13
12 and 13.
and 15.
12, 13 and 15. 12, 13 and 15.
বলছি।
Learned counsel for
17
the
টা
state
বলছি।
as well as WPDICL prays for time to file affidavit in opposition. Let affidavit in opposition be filed within
Give us 3 weeks.
3 weeks. Reply if any there to be filed within 2 weeks. 2 weeks. Full stop. Let all the full stop. After completion of all the pleadings, let all the matters be placed before this court. Give the April
My lord has kept the original side matters yesterday on 9th since the
that it will not come. I am keeping it
separately.
separately.
My lords, apart from the matters which are listed today in the appellate side, there are 2 matters.
I will come to you.
My lord, the time of
Yesterday-
exchange of affidavits is expiring on 10th as per lordship's present direction. So any day after 10th of April, my lord.
Which one?
My lord, in all these matters where lordship said, my lord,
what
3
that-
weeks and 2 weeks.
30 April.
No, only one thing, Milord, the original side matters except are fixed on 9th of April.
Let it be completed
Where?
in that reading.
Where?
30th April at 2 p.m.
30th April.
30. Yes, what about your matter?
Milord, only one more matter. Item number 7. Affidavits.
Item number
17. One singular matter.
17.
17.
Item 106 is the same matter challenging the virus of this act.
No,
Item-
Item number 17 record. The counsel for the state
এই 106
as well as WPTSL prayed for time to file affidavit in opposition. Let affidavit in opposition file within 3 weeks.
No, no.
Reply if any there to be filed within 2 weeks thereafter.
Okay.
ठीक है?
May I file the affidavit of service in connection? 17 রে
Affidavit of service filed by the petition. We kept it as per.
3 weeks.
Yes. And what is the matter?
Item number 17.
17 is over.
Yes. My lords, there are 2 matters filed by Ultratech.
Serial number.
But they are not listed today, my lords. They were initially tagged with the original side matters, which is why no order was passed on the last day.
No, yesterday it was fixed. You was stating that 126 or 127 yesterday.
My lord, I had appeared for item number 6, my lord, in the original side. The appellate side matters were not listed.
No, yesterday you mentioned 127. You are mentioning.
That was me.
Yes.
So in
So
today's
that is 106 in today's list.
Stress list. 106.
Yes, Milord. But here, Milord, though Milord I have served, but the originals are not here. Give us 2 weeks time to file it in court.
Record 106.
I'm filing my exception to the.
No, don't file it today because
Yes.
I'm seeking it.
Well,
106. So I am directly filed within 2 weeks.
Very.
The counsel for the state as well as WBIDCL prays for time to file affidavit in opposition within 2 weeks. Reply if any there to be filed within 2 weeks thereafter.
My lord, may I just seek a small indulgence? This matter may be tagged with the
Yes, all will matter come on 30th April.
Very well, I'm so
My
grateful.
lord, these two matters, affidavit in opposition has been filed by WBIDC and state. We are
But that is not in the list.
not today in the list, my lord.
So you give the number, it will be listed tomorrow as on Monday or Tuesday as it will be mentioned, then order will be.
This formal direction will be passed.
ঠিক আছে? All matter
স্যার ওটা কিন্তু ম্যাটারের নাম লেখা
individual not
দেখুন আপনি একবার
হ্যাঁ
না আগের বার হয়নি তাই বলছি আপনাকে
7-8 cost title. First on the one seat, I turn on WPA number so and so. Then second WPA number so and so. Third WPA number. Let all the matter be placed before
ওটা উপরেরটা না,
নিচেরটা। ওটাতে ওটাতে সব আছে लेकिन केस नंबर अलग है। ठीक है ना? Yes, call the list. 17 भी उसी में आ जाएगा। वो भी है सब। Yes, 18 my lord, I am for the respondent my lord, Indian Railways my lord.
But there is a further development in the matter. They have temporarily delisted me. Now, not during the pendency of the petition, they have issued me a show cause as to why you should not be permanently delisted.
My lord, one test report has come, my lord, from the
I'm sorry,
respondent number
yet to be
3.
affirmed. But for the timing, your lordship may peruse this, no, it's yet to be affirmed because of the uncanny promptitude with which the railways are moving against this particular petitioner. এখন affirm করে দিয়ে দিচ্ছি দাঁড়া, আমার কাছেও কপি নেই এখনো।
Yes.
নে আমার কাছে the principal point is the decision making process not leading to this delisting, number one, and number two, in the given facts and circumstances of the case, whether the policy at all permit them to temporarily delist me, because not the policy envisages certain situations where a party can be temporarily delisted. The foundational basis on which this temporary delisting order can be passed is there should be a position of rectification of the defect.
Correct.
Now, these are situations where the goods had been consumed, paid, further orders placed. So the entire action is not violative of the Sale of Goods Acts. But that I shall be arguing at the final stage.
So now today only extension.
But kindly extends the, I was praying for this.
My lord, they have been delisted due to their material. The material has been supplied that is low quality, my lord. That has been affirmed
Have
by
you
the
issued
Indian
the
Railway.
SOCOS?
Yes, my lord.
Issue the SOCOS.
Yes,
Hearing
my
was done.
Not show cause and the delisting order refers to a different show cause, a representation made by a completely different person with whom I have no relation whatsoever. But I pointed this out at the time of moving the petition. Please have a look at page 139, which is the delisting order in the second volume.
Yes. What interim order was passed?
Your lordship directed the particular tender not to be proceeded further with.
Correct.
Number the effect of this is not because of this temporary delisting, I am not being eligible to participate in the other tenders. But it's always in the nature of a rolling tender almost. But I have missed out on 3 tenders. This tender where your lordship has protected us. Please come to page 139 once. But the preposterousness of the action will be immediately revealed. Please see the reference. This office's show cause notice of event number dated 20th January 2025. But the first order was supplied in June 2025. Funds later dated so and so dated 22nd August 2025.
Yes,
this is not the reply to my letter.
Okay, I am extending. You take instruction with regard to this. So you will file affidavit.
My lord, I'll file a report, my lord. But already I filed the report, lord.
This report.
That is keep on the record. Lord.
Kindly permit me for a limited period at least to participate in the tenders. Not in the other matter, there was an interim order. Not they have tried to bypass this now.
If there is any tender notice has been issued.
Not one tender notice. I have missed out on 3 tenders. The last one, your lordship has been pleased to extend the time till 7.
He is telling that he will not use the affidavit. He will use this reply only. So you take exception. I am fixing a short date so the matter can be heard.
Kindly extend.
Petitioner has filed supplementary affidavit after serving the copy to the London Council for the petitioner respondent. Let the same be kept with the record. The respondents have filed the report and submit that they will not use any affidavit and they will rely upon the report filed by the respondents. Let the report be kept with the record. In view of the above, the petitioner is given liberty to take exception to the report, if any, within a week from date. Leave the matter. On 18th of March.
But may I only pray for this stay of operation of the final order for a limited time? But there are other tenders being floated. I won't be able to participate.
That's why I'm fixing a short date so that matter can be heard off.
Not in the not only thing, not this always in the but the other order which your lordship has been pleased to pass. Not this permitted the business to run. Now interim order down, Judge sector. Down. The other one.
Yes, what is the submission regarding Maran? Yes, the senior has come up.
Just coming up.
Yes, it's no problem.
What happened, Malad? Here, Malad, the interim order was granted. Interim order was granted, but the notification was floated by South Central Railway, Malad. They are not the main party here. And Malad, there is complaint against the product supplied by them. And Malad, the RDSO is the authority where is appellate provision is there. This is the third show cause. First show cause was premature. That's why it was rejected by my Lord Justice Amrita Sinha. Second, they come with before the vacation bench and obtain an order. Then that is extended by your lordship. Now the third time show cause, they are always avoiding to go before the RDSO. The RDSO is the proper authority, regards safety and security involved in this matter because the product has been supplied. That has been.
So that's why what I propose to do, you are harping upon the report which you have filed today. Correct. You will not file affidavit.
Well, report has been.
Report has been filed. You will not file.
I'll go through the report 17 onwards.
Correct,
but there is
correct. I have gone through. Let they file if any exception. Why you give during pendency of the case, pendency of the writ application, you issued this permanent disorder, impugn order?
No, this is not pendency, Malad. Because Malad, here Malad, so-called there are so-calls are there. They did not give a reply. Then delisting has been given. They should have challenged the delisting before the appropriate authority, that is appellate forum, as per 6 of the procedure.
Okay.
So Malad, we are not, and Malad, more so Malad, the South Central Railway is the appropriate authority. They have floated that.
They don't have authority to issue the temporary delisting order. I shall satisfy your lordship.
But because what temporary, since the complaint is one after another complaint is coming, and we kindly come to Malad page 130.
The buyer is satisfied, paid off all the dues, placed further orders.
Well, Malad, there is a continuing process. So that does not does not accrue any right.
What you are telling that you will harp upon this affidavit report filed by you. You will not file the affidavit.
Yes.
Correct. So what I propose to do, I am passing. I am fixing the matter within a short period of time, within 10 days. So not to give any effect to this delisting notice. Once the matter is pending.
Before passing your lordship's order, kindly see the 3-page. That is Malad, start Malad, chronologically it should come 128, then 127, then 126.
128
128 of the repetition. Well, kindly see on 17th 11/2025. The complaint was come up that these are the document, the CGRSP is broken in the third line of this letter.
128.
Yes, Malad. It should have been come first, Malad, because as per date chronologically it should come. Well, first, Malad, kindly see it. In connection with the above subject, the CGRSP RT 8747 laid down section such and such. During the period 30th August 2025 to 27th 9 2025 has been inspected. It has now been observed the CGRSP is broken at bottom horn, crushed at center, shows wear marks on the surface and cracked at the edge. The performance is unsatisfactory within just 2 months of installation. 5 sample pieces have been collected from the site and sent for further action, please. Then, my lord, in the following important document, in the first document, UDM warranty claim has been raised by the SSE, Senior Section Engineer, PWD. Complaint of reference dated 15/11/2025. On 15/11/2025, first complaint was raised against the supplied product. Then, my lord, kindly come to the next page. That is, my lord, page 19/11/2025. Performance here, the page 27, page 127, 127. It should have come chronologically, but it has come with haphazardly.
Yes.
First 126, then 127, then 128.
Yes.
Well, 127, my lord, kindly see 19th November 2025. The subject performance of CGRSP, WB sleepers, such and such, between the area. Under reference your letter, you have submitted and the unsatisfactory performance of MS Surya Alloy Industries Limited against the PO dated PO number such and such dated 26 June 2025 issued by Deputy CMM. In course of inspection, the process of inspection for item CGRSP, which was cited in the earlier letter, shall be followed as per specification T552023 Appendix P. The same was not maintained during the inspection, sample collection. Now you are requested to collect sample such and such as mentioned in the specification test, and collected samples shall be sent to ED such and such, RDSO. Now there is 2 samples are sent, one for testing, one for standby. If there is any complaint come from any site, then the standby sample will be tested again. Then, my lord, 126. At their presence, the Subhankar Sen, kindly see that next page 126 dated 5th December 2025.
Yes.
Subject matter for collection of sample. For collection of sample from field for retesting, as material supplied is found defective within 2 months of lying in between such and such area. But in connection with the above subject, the CGRSP laid between such and such area during the period 30th August 2025 to 27th September 2025, it has been observed that the CGRSP is broken at the horn, crushed at center, shows wear marks on the surface, and is cracked at the edge. The performance is unsatisfactory within just 2 months of installation. In UDM warranty claim has been raised, such and such, on 15/11/2025. The matter has been reported to such and such office authority for his information and necessary action. Now, as per advice of CTE, dated 19/11/2025, there is needed to collect sample from field and retesting. Now, this line is very vital. Sri Subhankar Sarkar, the marketing representative of Surya Alloy Industries Limited, has attended the office of SSE on 5th December 2025, and on detailed discussion, he has been suggested to call third-party agency for rechecking of material supplied. Here, our third party is the inspecting agency, Intertech India Private Limited. So, this
what has happened? Whether the testing was done?
But testing after testing, it has been found that
there is a testing.
That's report. Why the delisting was.
The testing report. It has been suggested to call the third-party agency for rechecking the material supplied.
At the time of lifting the materials, I wanted to be present. They said you are not required to be present.
The testing report. I shall produce the testing report, but where the safety and security is concerned, one of this particular.
Correct. I appreciate your argument, but your grievance is that the material supply is not up to the mark. That's correct. Then you have issued the notice, and there the representative of the petitioner has also attended, and after the discussion it was told that it has been discussed that it has to be sent to the rechecking. Whether the report has been come from any of the authority, the material was placed for the rechecking before any authority. Where is the report? The material supplied by the petitioner not up to the mark.
Because not the page 126 is issued to the person who had certified the materials before the same were purchased by the railways.
Entire lot was not
the agency appointed by railways.
That's why he has been given so cause he did not reply so cause.
What has happened after this letter?
Nobody knows.
5th December 2025. After
at least we don't know.
You have sent this
Lordship.
to the third party inspection agency. So what has happened after this?
With the RDSO is Malad, Lucknow Malad. I talked with him. They are coming Malad because in the meantime Malad sir.
How without receiving the report, how you can proceed? Once you have decided that the testing agency will test the material supplied by the petitioner.
I don't know Lordship or what is the Lordship's thing. But Malad, one thing Malad kindly see, Malad, if safety security is concerned, this particular authority has been given 3 times report that the defective.
Correct. I am not. Report is not against you. Only the report, the materials is not up to the mark. Within 2 days, there is a damage or whatever it is. There is a report against the petitioner. Then you have informed that. Then a meeting was conducted and you sent to the third party agency.
Kindly come to page 139. 139. One set of sample 8 mm such and such for farm initiation initial such and such dated 12th June 2005 were picked up during super check and sent for testing in RNP lab. MC dated RDSO, directed RDSO. The testing of the sample was conducted at the RNP laboratory of MC directed RDSO. As per MC test report, the sample was failed to confirm IRS specification RDSO such and such in the following parameters: tensile strength, elongation at break, relaxation modules, tension set.
Please contain. I just specific. Just a minute. My learned friend should indicate that this specification number is not mentioned in the show cause notice. He should indicate this.
For nitty-gritty, it should have been decided by the appropriate authority. That is the appellate authority. Why they are avoiding appellate authority? Every time they are coming, one thing about very astonishing, my senior friend, I have to learn many things from him, that the Southeast Central Railway is the appropriate authority. He has not made party, and he obtained the stay order against that authority. But the Southeast Central Railway Authority, Southeastern Central Railway Authority is the appropriate authority who floated the tender ballot. They obtained the injunction against that authority.
Respond number 2.
No, they are not made party. South Central Railway.
Respond number 2.
Southeastern, not South Central. Southeastern Railway, not Southeastern Central Railway. This railway has made a different zone, my lord.
Southeastern Railway is there.
Southeastern Central Railway is not the main.
Why the Southeastern Central Railway is the party? Where is?
Well, kindly pay 126. 126 or 164. 126 or 164. Well, kindly 164.
Yes.
Well, kindly see.
Yes.
Stores South Central Railway tender document. That is 2nd March 2026. That has been stated.
That has been
stay as per lordship directed me not to open the tender. The tender open date was 3rd March.
Okay.
These are the subsequent tenders issued trying to report to the lordship that this is the prejudice that is being caused by the delisting order.
The क्या बोल वो करता है ना?
My lord, may I take your lordship leave? अच्छा. आप जाने ना किचु
18 March. Yes, come on 18. 18 March.
18 March.
Under the same heading.
But would they file the exception to the?
Yes.
It's not subject to their handing over. Kindly permits us to the stay of
interim order.
Well, in the order, the personal authority has not been made party. So, in their absence, we have already communicated your lordship's order.
The operation of the order.
We have already communicated your lordship's order.
Kindly stays the operation of the order. Then
which order? No, already I am extending the interim order which has been passed.
But this would be
that is with regard to only one tender. But if the cascading effect of the delisting order is wheresoever the tenders would be floated, I will not be.
Come on 18, Mr. Majumdar. Come on 18. Interim order is extended till the next date of hearing. Yes, next.
Grateful.
Yes.
Supplemented the unaffirmed.
But this is the matter where the question of the permission from the authorization committee for kidney transplantation. My friend Mr. Bandyopadhyay was there.
अपम नहीं है छोड़ दो मत लिखो अपम नहीं है
পাখাগুলো কেন চলে যায়?
পাখাটা চালিয়ে দিয়েছে কেন তো যদি আপনি টুপি পরে আছেন আমরা টুপি পরে
আমার এমনি তো কষ্ট হচ্ছে এই
ভালো।
পাখাগুলো বন্ধ করে দিন এই পাখাগুলো
Yes.
পাখাটা বন্ধ করুন মাথা হাওয়া লাগে
Report let the
স্যারেরও বয়স হয়েছে আমারও বয়স
তাহলে মাথায় ভীষণ দিকে যায়।
अरे बंद करो फैन बंद करो क्यों फैन चला के रखते एसी नहीं है
এসি চললে যথেষ্ট ইনাফ এই একটা ইয়ে
Yes. What instruction you are having?
instruction lord I have taken instructions yesterday এটা জজ সাহেবকে দিন but I am handing over a copy to my learned senior friend
Appearance টা দিয়ে দিস, হ্যাঁ।
well according to the Lord, the provisions of the act 1994 Lord, everything has been taken into consideration. It was referred to the board. Board has not considered, but ultimately not recommended. But reason for not recommended, kindly consider that I have
That I am thankful to my learned friend. This is the approach of a lawyer of a state should be like this. That it appears that the reasoning is not a reason which can be at all adhered to.
that is up to your lordship, Lord. I have handed it.
এই তো 25 এটা উল্টো পাল্টা লাগিয়েছে রে রিজনটা কোথায়?
এই তো এখানে আপনার যে বোর্ড
কোন রিজনের পেজ কোথায়? এইটা পেজ 2
Yes.
Point to be noted that as per report of the verification committee, application may be
25
elected আর এইখানটাতে আছে আমরা এই যে আপনার 22nd September 2025. Hence, it is not recommended for the head, NOC of doctor and legal guardian of.
My lord will kindly turn me lord the letter dated 17th of July. Pagination is not there.
If my learned friend wants to, my lord, file an exception to the report.
No. I will not.
So that it will be on record.
I will rely upon the show from the report itself. That's very interesting. Kindly come to me at 17th of July. That this is by the Deputy Director of Health Service to the Chief Medical Officer of Health. Local police verification report to rule out clearly by stating that the sentence that there is no financial transaction and no middleman involvement. That this is the two criteria
Yes.
which are completely absent here. Therefore, I am entitled to get the order. There is no report that there is a financial transaction.
Whether this report has been obtained, submitted.
Yeah,
by
that
the
report
police.
was submitted.
Chief Medical Officer, Chief.
Then next page, 24th September 25. As per memo mentioned above, the verification report submitted by the SDO Barakpur.
Section 9.
Section 9(3).
Order দেওয়ার আগে it's my duty to point out. সৌরভকে কালকে ছেড়ে দিয়েছিলেন মামলাতে সৌরভকে বলবেন যে লেকচারটা কিন্তু প্ল্যাটফর্মে বাইরে সৌরভ চ্যাটার্জি আমি কালকে যেটা ছেড়ে হ্যাঁ আমি বলেছি নট এ প্লেস অফ লেকচার করলে বাইরে যাও স্ট্রিম নাও লেকচার
Can you see all presumption? The report is of 22nd September 2025. This is by the SDO. Whether there is any commercial transaction, Lordship, please notice. No. There are no unofficial financial dealings in cash or kind between the donor and the recipient.
What remains thereafter?
Who has submitted the page this round? Communication 22nd September.
Yes, that is
Chief Medical Officer.
to the Chief Medical Officer by the SDO.
SDO? No.
The report
SDO.
was sought from him
SDO.
that if this categorical finding there is no commercial transaction, that's the only consideration which could have stand in the way. Now, Loshu will kindly pass them to give consent, otherwise the patient will die. 9.3. Section 9.
If any donor authorized removal any.
And board meeting, Lord, your Lordship kindly see the notice, 9th January 2026. Authorized persons of the following organ transplant claims patients are directed to attend the
hearing
yes. Patient hearing did not patient need not attend the so authorized person. No, 9th January 9th January communication notice.
The section 9 subsection 3 says if any donor authorizes the removal of any of his human organs so transplantation in the body of such recipient not being a near relative as is specified by the donor by reason of affection and attachment towards the recipient or for any other special reasons. Such human organ transfer shall not be removed and transplanted without the prior approval of the authorization committee. Now, we had approved the authorization committee. The basic two queries, whether the monetary transaction or not, whether any middleman is involved. The SDO categorically says there is no commercial transaction.
Correct.
Then why would they keep me, unfortunately, where the patient might die? And the Bellevue Clinic I have annexed. It says this condition is down here. The condition is very bad. And let's kindly come to section 23, subsection 2. The authorization committee shall expedite its decision-making process and use its discretion judiciously and pragmatically. The statute also wants them to behave pragmatically, and I am benefited by the observation of my learned friend. He also advised them that to act pragmatically.
Committee should in writing reason rejecting. Yes, which provision you are?
23 subsection 2.
The authorization will expedite the decision making process of judiciously and pragmatically. In all such cases where the patient requires transfer.
And now the Bellevue Clinic is a well-known medical institution. They say on 4th November 25, this immediately necessary. I am reading out. Her current complaint is being physically unstable. Physical and clinical health is deteriorating day by day. Suffering from lots of uremic symptoms and under maintenance hemodialysis twice in a week. Considering current physical and clinical condition, my advice is urgent real transplantation to save her life.
Urgent renal transplantation. Yes. Yes, Mr. Banerjee.
But I leave it to your Lordship. I have seen the report, but here, my Lord, here only one letter I have found that "19th of November 2025, the Deputy Director Health Services, MERT West Bengal."
19th November.
This letter 19th of November 2025. This was sent by the Deputy Director Health to the CMOH. Case Miller, the recipient Rita Santhalia, donor Rahul Chaudhary. You are requested for re-verification of the district level verification report As recommended by legal cell and state level authorities.
That was also done.
Page 89.
That is at page 18. That was also.
But I have taken the instructions. I have submitted before your lordship. But it is up to your lordship after verifying the report.
My lord,
if it comments to the court, but I will not stand in the way. But it is my duty, my lord, to take instructions. That's why yesterday I have taken time. And the instructions, my lord, I have taken.
Yes.
So far as the my but thinking blood, the reason for rejection, I told them all. Well, come to court. I told them. Understand conjunction is found here. You have every authority to stop. A matter of one life.
No, specifically in absence of any commercial transaction, they cannot stand in the way. Lord should kindly pass an order so that the operation can be done tomorrow.
There is no unofficial dealing in cash or kind between the donor.
That's the only consideration.
That I've seen. I've seen that. That's why I told them also.
Yes, the petitioner has filed the present date application. Praying. Praying for setting aside and quashing the oral rejection relating to the authorization of renal transplantation of the petitioner's wife. The petitioner's wife.
Your lordship, kindly record, but I have already handed over a copy of the report to my
Yes.
And whatever maybe the order, let it be court sorted.
The petitioner's wife was diagnosed with kidney problem on 4th of November 2021. The dialysis through the central line.
May I take your lordship?
Yes. The dialysis through the central line has been started in respect of the petitioner's wife from 27th of November 2021. On 30th May 2025, the respondent number, the Bellevue Clinic advised the petitioner's wife for renal transplantation and to collect necessary documents for the same. On 26th of June, the Bellevue Clinic forwarded the application and other relevant documents of the petitioner and the donor to the authorization committee from a Department of Health and Welfare Government of West Bengal. The respondent authority issued a memo for provisional list of the patients for organ transplantation board meeting, which was scheduled to be held on 14th of October 2025, wherein the name of the wife of the petitioner's name is also appearing. The respondents have issued another provisional list of the patients of organ transplantation for which the board meeting is to be scheduled on 13th of January 2026, and the name of the wife of the petitioner is also appearing in the said list. The petitioner had been to the office of the concerned respondent for the reason of such refusal of transplantation of the organ, wherein the concerned authorities have refused to give any rejection order in writing against the application submitted by the petitioner for approval of transplantation of the organ in writing to the petitioner. Accordingly, the petitioner has filed the present writ application. The authorities have filed the report after serving the copy to the learned counsel for the petitioner. Full stop. In the report, it is mentioned that that in the report it reveals that the chief medical officer of health, North 24 Parganas, by the letter dated 29th of December 2025, requested for a verification report from the SDO Barakfu subdivision, North 24 Parganas. The subdivisional officer Barakpur, North 24 Pargana, has submitted the report on 24th of December 2025, wherein it is categorically mentioned that there is no unofficial financial dealing in cash or kind between the donor and the recipient, as per the affidavit from first class magistrate, police verification reports and declaration of the donor and the legal guardian. The reason why the donor is desirous to donate the kidney is also mentioned in the said report, wherein it reveals that the donor wants to give the kidney to the recipient on humanitarian ground, as per the affidavit and after interrogation of the, after examining the donor. In spite of receipt of the said report, the authorities have rejected the request on the ground that during the interview, both the donor and the legal guardians of the recipient were asked to submit some additional document within 1 week to establish that both their father and father of the donor and the recipient were well known in connection with the business. They have submitted invoice of 2019 that appears to be freshly prepared. It appears that those documents may have been manipulated and fabricated for the purpose of submission only. In the light of the above mentioned, old relationship between the donor and the recipient could not be established beyond the reasonable doubt. Accordingly, the authorities have not recommended the case of the petitioner. Section 9, subsection 3 of section 9 of the Transplantation of the Human Organs and Tissues Act 1994 provides that if any donor authorizes the removal of any of his human organs or tissues or both before his death under subsection 1 of section 3 for the transplantation into the body of such recipient not being a near relative as is specified by the donor by reasons of affection or attachment towards the recipient or for any other special reason, such human organ or tissues or both shall not be removed and transplanted without the prior approval of the authorization committee. Section 23. Section 23 provides for decision of the authorization committee. Subclause 2 of section 23 provides that the authorization committee shall expedite its decision making process and use its discretion judiciously and pragmatically in all such cases where the patients require transplantation on urgent basis. In the present case, admittedly, the wife of the petitioner is suffering from kidney problems since the month of November 2021 and under dialysis since 27th of November 2021. The Blue View Clinic has issued the certificate wherein it is certified that considering her current physical and clinical condition, my advice is she needs urgent renal transplantation to save her life. From the certificate issued by the hospital authorities, it finds that an urgent renal transplantation is required to save the life of the wife of the petitioner. The donor the donor, though is not a relative of the wife of the petitioner, but has filed an affidavit before the London First Class Judicial Magistrate stating that inward comma, I am donating my kidney to my well-wishers, namely Rita Sonthalia, wife of Neeraj Kumar Sonthalia, aged about 43 years, by faith Hindu, by occupation housewife, on humanitarian ground, without any pressure or any financial consideration, only to save my well-wisher, namely Rita Sonthalia. The donor has executed the said affidavit before the London magistrate. The police verification report has also been called for, and in the police verification report also reveals that even leaving aside the affidavit affirmed by the donor, it was found on examining the donor, it was found that that the donor wants to give the kidney to the recipient on humanitarian ground, and no financial dealings in cash or kind between the donor and the recipient as per has been found by the police authority. The authorization committee has refused the request of the petitioner only on the ground that that they have submitted an invoice of 2019 that appears to be freshly prepared and is manipulated and fabricated. This court failed to appreciate that once the donor has given an affidavit, though it was executed before the London magistrate, stating the fact that he is the well-wisher of the patient and intend to donate his organ only to save the life of the patient. And during the police verification also did not find that any financial transaction has been made. But the authorities in a flimsy manner has refused the request of the wife of the petitioner for giving the authorization for transplantation of organ. Considering the above, this court find that the reason on which the authorities have rejected the request for transplantation of the organ is not in accordance with law. This court find that the donor has voluntarily came to donate the organ to save the life of the wife of the petitioner, being a well-wisher, and he has also affirmed the affidavit before the London magistrate, and that has also been verified through the police authorities. Thus, this court did not find any, and thus this court find that the reason on which the authorization committee has rejected the request of the petitioner is not in accordance with law. Who is the authority?
The authorization committee.
Respondent number 4.
Director of Medical Education.
The authorization committee.
Yes, no, he is the head of the authorization committee.
Yes, the respondent number 3 and 4. 3 and 4 are directed to reconsider.
No, reconsideration will not do.
Okay. The respondent number 3 and 4 are directed to immediately grant permission.
Yes.
From after going through the certificate issued by the hospital authority, that is the Bellevue Clinic, dated 4th of November 2025, this court find that the current physical and clinical condition of the patient needs urgent renal transplantation to save her life. As per section 23 of the Act of 1994, provides
There's subsection 2 of section now. We don't know.
23 subsection.
Section 23, subsection 2.
Provide. Section 23, no?
No, correct. Rule. No, this is under the rules, rule 23, not section. I'm sorry. Transplant and human organs tissue rules 2014. Rule 23.
Rule 23. ऊपर में rule आएगा.
Rule 2.
Rule 23 provides that the authorization committee shall expedite its decision-making process and use its discretion judiciously and pragmatically in all cases where the patients require transplantation on urgent basis. In the case this court finds that the authorities have not complied with the rules of 2014, though the patient requires the urgent renal transplantation to save her life. Accordingly, the respondent number 3 and 4 are directed to take appropriate decision and to permit the petitioner, who is the private respondent? He's not a party here.
Permit, my lord, the petitioner.
Permit the donor. Permit the donor, namely
Rahul Chaudhary.
Permit the donor Rahul Chaudhary, son of Sudhir Chaudhary, resident at 2 number Bijoy Nagar, VTC, Nihati, सभी अलग कर देना है. Nihati, to donate
the kidney, my lord, in favor of
to donate the kidney
in favor
of the wife of the petitioner, namely Mrs. Rita Santhalia,
yes,
who is at present admitted in Bellevue Clinic.
Right.
As an indoor patient, admitted as an indoor patient. Not admitted. Who is under medical treatment? Who is under medical treatment at the Bellevue Clinic, Kolkata.
Right.
Kolkata. Immediately, within 24 hours, full stop. If the authorization committee has permit, full stop. Immediately after getting the permission from the authorization committee, the hospital authorities are directed to take appropriate steps for transplantation of the kidney of the petitioner within a period of within 24 hours thereafter.
Another indulgence, but if this order will be uploaded
Today. But evening it will you will get. Thank you.
Communicate your order will follow. Yes, you may be given liberty to communicate the gist of the order.
The petitioner, as the matter is urgent in nature, accordingly petitioner is given liberty to communicate the gist of the order to the authorization committee, and the authorization committee is directed to act on the gist of the order passed by this court.
Notwithstanding, without the Saturday and Sunday. Otherwise, it will again go
within 24 hours, notwithstanding, keeping in view of the Saturday and Sunday.
Yes.
26, I am for the petitioners. The same and identical issue.
Same.
Only the hospital is different. I don't know what
report is same.
I think the reason for rejection is reholds the settlement. I've gone through it, Lord. It strikes at my conscience, Lord. Lord, please have a look at page 9. The rest of it is exactly similar.
Same. Saurabh, এটা করে দেব নামটা চেঞ্জ হবে বাকি সব
only it's ILS hospital.
Hospital is ILS and donor affidavit is there.
He's a affidavit is there and he's also a party. Respondent number 8. His affidavit, you also want to see his affidavit.
Okay. Same order.
Same.
Only hospital will be changed.
ILS hospital.
Thank you.
ILS hospital, Dom.
So now you got the ILS.
Great.
Thank you.
Milord, may I beseech your lordship, Milord, I am the respondent number, petitioner number 5 appearing in person for self, and all other petitioner. Here is my letter of notarized authority. If your lordship kindly remember, my lord, on 8th of December, your lordship passed an order for appointment of a special officer in our housing society for a remuneration of 3 lakhs and odd. And my lord,
Yes, now what is your grievance?
no, like, grievance, my lord, on 14th, the matter came up before your lordship. I appeared before your lordship. Your lordship passed an order, but couldn't pass any effective order as to the appointment of an officer since I was devoid of.
Now what is the
authority.
grievance?
Now, my lord, what has happened, my lord? They have come up with the same third-party agency has come up with an election notification, my lord. Kindly see, my lord. They are going to hold the election on 11th, my lord. In contumacious disobedience of your lordship order.
Last order was passed by this court on 14th January.
14th, my lord.
Thereafter you slept over the
No,
matter.
twice
Once the notice has been issued by the third
my lord,
party,
I have got the my lord video clippings, my lord. Twice I mentioned it was listed by your lordship directions. It was listed at the tail end erroneously, my lord. And thereafter certain disturbances cropped up in your lordship's court.
Domain of the developer,
No.
Look up the deed of the country.
My lord.
Yes. But
my lord, kindly see the order of the competent authority.
Clause G. This is the deed registered, photocopy registered.
My lord, it is being opened up all along again, my lord.
This is absolutely our domain.
It is not their domain, my lord. The SGM was held. A resident owner was selected as a appointed as a presiding officer. And thereafter, considering the dispute in details, your lordship passed an order for presiding officer. And my lord, thereafter, unfortunately, for want of my authority, the effective order could not be passed. But how did they get the authority to go on with the election? And my lord, if this is allowed to do, my lord, the writ petitioners and dozens of other residents will be debarred from contesting the same.
who are you?
My lord, I am the resident owner.
You are the resident
Yes, all petitioners are the resident.
You are also the apartment owners.
Yes,
How many apartments owners are there?
1,639 voters are there.
1,639 voters.
39 voters are there.
Correct. So now what
kindly appoint a special officer and allow him to hold the election within a time bound. We are never against the election. Never. In terms of rules and bylaws, as your lordship directed.
Cost should be bear by him.
No, my lord.
Because kindly see clause G. We are waiting for so long period. They went to RERA. RERA passed an order. In terms of order, we are trying to hold the election.
My lord,
just a minute.
My lord, I have no issue whether special officer appointed or we won the election, so the association will inform, we can discharge our liability.
Correct.
That is. But the amount,
who has issued this notice?
My lord,
who is he?
This is the registered deed.
No, who is he? Jasri, what is your name? Rajashri Ghosh?
My lord, he is the head of the third party agency, director of the third party agency.
As per this clause G.
Clause G, whether he is the having the experience of conducting the election?
No, my lord. No, never.
Just a minute. I am asking you. You will get the chance. That is the problem with all of you.
My lord.
Other 6 and 7 projects.
Projects no, with regard to the election.
No.
This is their job.
Yes, what is your objection with regard to conducting election by this party?
My lord, they were appointed prior to the holding of the SGM where it was to be decided. My lord, kindly see the order of the competent.
What is your problem? You tell me.
Problem is that they have kept the database with them. They are not disclosing anything. And
what do you want to disclose? What do you want?
The entire particulars of the non-resident owners, my lord. They are not disclosing.
So there is no list of the voters.
No. They have, and my lord, kindly see they have taken 2,000. This is their document, terms and conditions.
What?
2,000 from every apartment owners, my lord, for association formation. And now they are denying to pay the special officer appointed by your lordship.
No, they are not denied. The special officer appointed by this court has mentioned before this court.
Another one, my lord, there are lots of.
So that's why I'm telling. That's why I'm telling.
Members, my lord.
The senior member has, senior learned advocate has came before this court. On your presence, it was mentioned. Yes. Then you have taken this. You have not taken any steps till date.
Twice I mentioned, my lord. Kindly.
What can be done?
My lord, kindly. The matter was your lordship directed, my lord, as to be mentioned, and my lord thereafter it went up, told down the list erroneously. Kindly see, my lord, video clippings I have with me myself on 15th.
Who will give the remuneration of the special officer?
My lord, the builder, my lord, kindly see this. The builder has taken 2,000 from each and every apartment owner. Each and, my lord, kindly allow me to finish, my lord. I have also other documents. I have also, yes. And my lord, also kindly see the website copy, my lord. My lord, extra charges they have taken. My lord, kindly say, at the time of sale of each and every apartment, they have charged more 2,000 and more than this is the.
Sir, one thing you clarify before this.
Yes.
Vote. How many persons? How many the resident owners are there? Flat owners are
Nearly 2,000 million.
nearly 2,000.
Out of them, 1,639 have their registered deed and are entitled to participate in the election.
Okay.
So, my lord, huge amount, my lord, is lying with the builder.
So who will pay the amount?
Builder, my lord. Of course, builder should pay. And my lord,
already, my lord, the pay the third party agency for conducting this.
but that was.
I can display each and every.
Okay. How much amount you have given to the third party?
Come with this one of the entire one.
Yes, you come with the what the amount you going to.
By 2 p.m. I will come.
What the amount you going to spend for the private party?
Yes.
For conducting an election, cum with that amount is to be transferred to the special officer. Special officer will conduct.
Much good.
Any expenditure, one of already
Already explained, whatever it is, that is that.
No, my lord.
But
But my lord, association is yet to be formed.
I feel so one of the expenditure which I have incurred for the conducting the expenditure, entire thing, the third party should transfer to him.
Okay, no problem. Okay, no problem. Let this party continue. I will appoint the special officer. Continue with this. No problem.
I have no problem.
And the special officer remuneration shall be given by the builder.
Yes.
Yes,
Then.
Whatever the amount you have collected.
But I am giving the expenditure. Right now, I am not the exact figure. I will by 2 p.m. I will
Come tomorrow with the total accounts.
Tomorrow, Milord, Monday and Tuesday, Milord, there will be resolution, Milord. Kindly, Milord.
What resolution?
Milord, the resolution due to Bar Council election, Milord. If he assures, Milord, I have no difficulty.
The court is not having the resolution. Court will sit. If you are having an urgency, you come to the court.
Milord, I
urgency, then go to the.
Milord, I must come.
This court is totally against with regard to the resolution, not to work.
No. Milord, I am not.
The government has paid us for the work.
No. Milord, they have.
If you go with the bar, you go with the bar, then leave it. Other matters there. Other advocates will appear and they will take the matter.
I must come, Milord.
I must come. The London advocate appearing for the builder. You are appearing for the builder?
I am appearing for the builder.
Builder, submit that. He will produce the total accounts for the purpose of conducting election of the society.
Yes, Milord.
Election of the society. Let the account be filed on
election of the association.
Election of the association. Let the account be filed on 10th of March 2026. Let the matter appear within 3 matters under the heading motion, urgent motion on 10th of March 2026. Next. Yes, take.
Much grateful.
Next.
Item number 19.
Yes.
All pleadings are completed, and on the second time while extending interim order, when I made submissions, my lord, with my learned friend also, that this is a short matter, lordship fixed it for completing the matter. Well, I made a just 2-page list of dates in case there is a requirement, because I don't think it will be much requirement, but even then, I said. Now, for the time being, lordship is not required to see list of dates or not even the petition also.
Okay.
My lord, when the crops, some of the crops that in India that we export, and there are certain crops that we import. I happen to be one of the agencies
whose job is this, that when the crops go or crops come, there are governmental functionaries, they decide and see that no foreign pest should come in the Indian soil. So once they decide that no, these crops required a this is called a fumigations. Basically, in simple way, it's a pest control. Pest control. So if they decide that, let's say that some crops has come from Ukraine, once they decide that this needs to be fumigated before it goes to the India. So there are several accredited licensed agencies. These are the private bodies like me. They will say like X, Y or Z, you fumigate it. So our job is to do the fumigations.
At like a quarantine.
It is like a quarantine. Now quarantine is if the governmental agencies find that there is a requirement to keep it in a quarantine separate. So they will, there are storage, there are facilities.
The facilities are there.
It is fundamentally a logistics which the government, they may not have, but decision, certificate, everything is done by the government officials. I basically, with my expertise, I mean, this proprietorship farm, that do that pest controlling thing that I have been doing. But now Lordship kindly take the list of dates. 2005, my lord, that I have been continuing, and there are approximately 45 persons who are working with me. The reason, my lord, I am before your lordship is that I have been banned by the authorities. X, Y, Z could be the reasons, but without any show cause, without admittedly, because they took us without any form of natural justice at all. They simply say that there is a banning order. From the date onwards, I won't be able to carry out my business. So my entire business with 45 persons were at stake. Immediately rushed before the Honorable Court. The Honorable Court protected me. So thereafter, I am continuing. And today is the hearing. Now, the reason for the banning was this. My lord, one criminal case was started. Now, Lordship may kindly take this list of dates. Lordship will see that first, 12th of January 2018, that date, CBI one registered a case. Fundamental case was against some government officials who were supposed to issue certificates. Now they found that some government officials, they are taking bribes and issuing the certificate, so not properly being done. That was the case. For this case, the petitioner number 2 was arrested. Lordship may kindly see the date, 23rd of December 2021. Within 10 days, he was released also. Because, my lord, there was CBI thought there is a long chain, though ultimately certificate is issued by the government officials. So, but even some agencies which are part of that criminal activity. So petition number 2 was, my lord, arraigned with this criminal proceedings, arrested and granted bail.
Release,
Also.
yeah.
Now, thereafter, my lord, there was no difficulty in running the business. It was continuing, and every time there is a renewal, and that's a very strict kind of thing, kind of assessment, everything done. Thereafter, that renewal validation is done, which is in my case is still there up to 30. Now, the impugned, my lord, suddenly on 14th of January 25, my lord, which is the impugned one, by the impugned, the concerned authorities, they suddenly say your business is banned. What is the reason? CBI made a recommendation, and on that recommendations, I don't get anything. They take a decisions, your business gets banned. That is under challenge. If Lordship make,
yes,
if I can, this is the, my lord, sum and substance of the case. I will go to the legal point, but before that, I need to show exactly the banning order. Only for the purpose of page 20. But you will see the very subject itself.
Page 20.
Yes, 20. Lordship, see the very subject. It says the banning of business association of pest control agencies of Sanjay Choube, namely, that's the petitioner, and property of management of such and such. So this is now this banning of 14th of January 25 has been done. For running this business, there are certain specified guidelines which are strictly required to be followed. If Lordships kindly have a look at 2.5 to bar kore dao. This is called National Standard for Phytosanitary Measures, short is NSPM 12. Kindly take, my lord, 2.5, which is at page number, page number is at the, that is opened. Suspension and reinstatement protocols. The plant protection advisor shall immediately issue a show cause notice to the fumigation agency and accredited fumigation operator that perform ineffective fumigations operations, which includes receive a such and such. Not necessary. Lordship may kindly come to the next page. Next page, first line. In the event of suspension thrice or more within 5 years period, the branch agency and operator will be blacklisted. I'm pausing for a moment. It prescribes two things. Number one is the show cause. Number two, there is a C. So if I can in one word, there is a form of you are doing this bad. Let me know why. So some kind of cautions, and there is a period, then blacklisting can be done.
Correct.
In this case, it is absolutely zero, not even a show cause. That's the reason, my lord, when this was moved, I submitted before the Honorable Court that I am not going into any points. I take only these 2 points. My point number one was that prescribed procedure has a detail how blacklisting can be done. They have completely ignored it, number one. Number two, their sole reason is that CBI recommended them.
That is not the reason.
That's the only sole reason.
No, that is not the law.
That is not the law. Now straight away I come to, for these are the two propositions. On these two propositions, my lord, I have got the specific judgments because this matter need not be made so lengthy because this is to the point. So on the first proposition, that, and before I say the propositions, my lord, these are the situations where there is not even a prescribed detailed mechanism for blacklistings. Unlike in my case, there is a mechanism. Even if, assuming that this is not there, even then, a natural justice has to be proper.
Yeah, that is a settled law.
Settled law. Now, first, Lordship may kindly take the daffodil. I will go to Lordship's judgment at the end because Lordship has dealt with this also in Helix. First is 2020 18 SCC 550, paragraph 15. In fact, 13, 14, but I would make it the most important. Unnecessarily, I will not go to the lengthy one. So kindly come to paragraph 15.
Yes.
In the present case, even if one assumes that Surrender Chaudhary, the accused in the pending criminal case, a similar case, was involved and had sought to be indulged in objectionable activities that ipso facto could not have resulted in unilateral actions of the kind which the state resorted to against the daffodils, which was never granted any opportunity of hearing or a chance to represent against the impugned order. If there is one constant lodestar that lights the judicial horizon in this country, it is this, that no one can be inflicted with an adverse order without being afforded a minimum opportunity of hearing and prior intimation of such a move. This principle is too well enriched in the legal ethos of this country to be ignored as a state. Now, this paragraph 14 of 2020 is based on, it's very 75 Eurasian judgment, 1975, 1 SCC 70. Paragraph 20. I have taken the list of I know that it is well settled, there is no requirement, but only to show before your lordships that there has been a consistency and there is no dilutions on this part of branch of law. even in 75 1SC 70 paragraph 20, blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationships with the government for purpose of gains. Now, this is Article 19(1)(g) that to carry on. The fact that a disability is created by the order of blacklisting indicates that the relevant authorities to have an objective satisfaction. Fundamentals of fair play require that a person concerned should be given an opportunity to represent his case before he is put in this case. Now, kindly see, this was 75. Next, 89 1SCC 229. And my lord, one thing that this 75 was of a larger bench of the Honorable Supreme Court. This was by the bench. Yes, it is the larger bench.
Yeah,
Not
larger bench.
It's not a constitutional, not five, but
Three judges bench.
Yes, so larger. So then, my lord, 89. Paragraph 4. Well, what exactly I was making submissions that in my case there are specified guidelines. Now, it's not just the submissions. It was a case even if it is not there. My paragraph 4. Indisputably, no notice had been given to the appellant of the proposal of blacklisting the appellant. It was contended on behalf of the state government that there was no requirement in the rule of giving any prior notice before blacklisting any person. Insofar as the contention that there is no requirement specifically of giving any notice is concerned, the respondent is right. But it is an implied principle of the rule of law that any order having civil consequence should be passed only after following the principles of natural justice. It has to be realized that blacklisting any person in respect of business ventures has civil consequences for the future business of the person concerned any event. Even if the rules do not express so, it is an elementary principle of natural justice that parties affected by an order should have right of being heard and making representations against the order. Now, I'm not reading anything further. Now, this has also been in 1994. Lordship may kindly see the flow of such a consistency. 1994 supplementary to SCC 699, paragraph 11. Yes, paragraph 11. The deletion of the appellant's name from the list of approved contractors on the ground that there are some vigilance report, in my case it's the CBI, against it could only be done consistent with and after due compliance with the principles of natural justice. That not having been done, it requests to be held that withholding of the tender from such a was not justified. In our opinion, the High Court was not justified in dismissing the writ petitions. Thereafter, this 2021 1 SCC 804, paragraph 9 and 12. Well, 9 I won't be reading because 9 is that 75 Eurasian that has been quoted. Only 12. Lordship may take note of 9 and 12 both. But I am reading only 12.
Yes.
9, 75 followed, then 12. In view of the aforesaid conclusion, there may have been no need to go into the question of the duration of the blacklisting, but for the arguments addressed before us, an order of blacklisting operates to the prejudice of a commercial person, not only in presenti but also puts a taint which attaches far beyond and may well spell the death knell of the organization institutions for all times to come, described as a civil death. So therefore, there is a requirement.
Yes.
Well, then I will come to Lordship's judgment. In fact, Lordship has also considered all these judgments, and then that this is 2025 SCC online, Calcutta. Lordships might have forgotten because of thousands of other matters, but it is our duty to remind also to your Lordships that that's the reason I said that I won't be beginning. Usually we begin with the judgment of the Honorable Court Fair, but I thought no, I will come there because now 25 SCC online Calcutta, kindly see there are 3 paragraphs, paragraph 16, 17 and 19. 16 Lordship has,
That the clause.
yes, and then can you come to 17? The contention of the respondents that in the show cause, in fact, this was a case, show cause was there, but show cause did not say that I'm going to blacklist.
Correct.
So therefore, it's even, in my case, even much better. In my case, I don't even get a scrap of paper. One fine morning, because
Blacklisted.
yes, me and all 45, basically they are the laborers. They suddenly that we are having our entire livelihood just because the CBI thought that recommendations 19(1)(g) gets a complete the pause. 17, the contention of the respondents that in the show cause notice as well as the personal hearing notices issued to the petitioner, it is categorically mentioned that penal actions will be taken against the petitioner as per the terms and conditions of the tender document. From the show cause notice as well as personal hearing notices, it reveals that the respondents have not stated or mentioned that the respondents will impose the penalty of blacklist and debarment upon the petitioner. This court also finds that respondents have passed the impugned order of blacklisting and debarring the petitioner from participating in the tender on the ground of supply of non-standard quality of medicine. But the respondents have not supplied the report on the basis of which the respondents have come to the conclusion that the medicine supplied by the petitioner is of non-standard quality. The respondents have neither informed the petitioner in the show cause notice and the personal hearing notice with regard to the penalty which the respondents are going to impose upon the petitioner, and have also not supplied the report so as to enable the petitioner to file any objections, if any, to the said report. So ultimately, 19, kindly see, my lord, that was Lordship ultimately found this was in violation of principles of natural justice and set aside that.
Yes.
Now, the last by a division bench, it's an unreported, presided over by the Honorable Justice Tandon. My lord, this is FMA 853 of 22. My lord, I shall give the page number. Kindly, my lord, the paginations are there, right hand side bottom. Kindly come to page number 20. Oh, sorry, right hand side above. Page number 27.
Yes.
It emerged from the aforesaid decision that even if right to be heard before a person is blacklisted is consistently absent in the agreement, which is not the case in my case, yet it is obligatory on the part of the authorities to follow the principle of natural justice because of the serious consequence which follows from such action of blacklisting, debarring a person entering into a future contract with the government or public authorities. Any actions which defies the principle of natural justice, which is ingrained and inherent as public element, shall entail the action of the state or the public authorities liable to be struck down. We thus do not find any ground warranting interfering with the impugned order on the facts and the law applicable in this ground. So impugned order was that blacklisting was set aside, challenged before the Honorable Division Bench, and therefore, ultimately, this is the principle. Now, my lord, the very fundamental principle on which basis this line of judgments are based on that three proposition. Proposition 1, 3 judgments. That, but I was trying to think even as if I have a worst case. My worst point, which could be today, if the proposition of law becomes this, that if there is a pendency of a criminal case, that means he will not be able to carry on any business, 19(1)(g), then what will happen? The first thing what will happen that the principle of innocence till I'm not found to be convicted. That principle, which has been found by consistently by the Honorable Supreme Courts to be not only it's a principle arising out of even the human rights, that will completely be obliterated. On that principle, first, my lord, this 2004 10 SCC 699, paragraph 30. I know 31, but you have to. Well, I shall be It's basically 30, but I would also read 31. 30, it is now well settled that benefit of doubt belong to the accused. It is further tried that suspicion, however grave may be, cannot take place of a proof. It is equally well settled that there is a long distance between maybe and must be. Now 31. It is also well known that even in a case where a plea of alibi is raised, the burden of proof remains on the prosecution. But this next sentence, presumption of innocence is a human right. Such presumption gets stronger when judgment of acquittal is passed. Rest is not necessary. I am only on that sentence, that today there is a pendency of the criminal case. Yes, I am an accused. I was arrested, released, and that too long ago. And that's also within 10 days. But fundamentally, what happened? It's fundamentally case against some officials of them. I am a private agency. The CBI wants me to make some statements against the officials. Now, I did not. So this is the way they that.
With regard to the criminal prosecution, that is totally depends upon the evidence and the final.
Correct.
That cannot be immediately after the registration of the case, and you should be debarred from holding the business.
But I need not say anything. Only since I have brought it, well, on the principle of innocence, 2011, 2 SCC 83, paragraph 18. Because the reason I have searched it, because we keep saying, my lord, these propositions, but often I have not. Only there is one judgment of our court. So, my paragraph 18, the last paragraph. This is the portion of within the court which starts with 39. Every accused is presumed to be innocent unless is guilty is proved. The presumption of innocence is human right. As I was saying, that recognition of human rights, that is a very consistently. I need not read anything further. The last one, this is the division bench of our court. It is unreported. In Prova Sharma, CRB division bench number 4148 of 2022. I shall be placing the page number 2. First is page number 2, last para. Page number is bottom.
Yes.
Last para. The principle is as old as the hills in the countries where there is rule of law as understood by the Anglo-Saxon jurisprudence, that unless required to prevent commission of a crime, normally a person cannot be detained in prison without trial by any state authority. The principle which flows along with this constitutional principle is that a man is presumed to be innocent unless proved guilty, and that a person is proved guilty of a criminal offense only if his guilt is proved beyond reasonable doubt. But that's what precisely Lordship was saying. And this is also echoed in last page number 9. There is, it has been very, very shortly summarized. In Roman 1 to, I am on the Roman 4. There is presumption of innocence. In fact, my lord, it starts from Roman 1 also.
Yes.
Roman 2 also. Yes.
Yes.
That's the reason I said that this is a short matter. I don't think I am required to say anything.
Thank you.
This is, and I am seeking setting aside.
Yes, sir.
Hello, Pastor. I would like to present your lordship only 4 points. That is, first and foremost, why he has been, the petitioner has been
Blacklist.
And the depressed, and why have not have been shown in notice previous. First and foremost, my lord, kindly come to page 8 of the para 9 of our evidence. Page 7, para 8. Page 7, para 8. sentence, para 8.
Yes.
The fifth sentence starting, the petitioner has been released. The petitioner has been found by the
Page.
page 7.
Affidavit in opposition of the respondents. Page 8.
Paragraph 8.
Paragraph 8. Page 7.
Page 7.
Yes. Yes.
Fifth sentence. Has been found
Yes.
by the CBI of committing offences related to
Forgery
of phytosanitary certificate. It's not any sort of crime, any sort of mischief or violation of trivial or anything like that, like non-payment of fees or delay in registration or non-maintenance of quality, all these things. This is a severe and heinous crime of forging government certificate of a foreign country, complicity in corruption, and not only he was alone, he was in a complicity and in a conspiracy with some other person, and shielding other similar entities who were otherwise liable for penalty. The CBI, in course of its investigation, has collected sufficient evidence of the same. The CBI has registered a case bearing case number so and so, in connection with which charge sheet has been submitted, and the case is presently heard by the CBI court number 1, Alipur. This is the nature of this crime, which has already jeopardized our national and international relations in business, in this way. Next, kindly come, my lord, to page 8, para 9.
Yes.
Of the same position. Page 8, para 9.
Yes.
Before that, my lord, kindly come to the page 8, the second sentence, second line. The gravity of the offense.
Yes.
The gravity of the offense has surfaced for petitioners in investigation conducted by the CBI was severe to the extent that necessitated prompt action.
You tell me one thing. Without the trial, one can be convicted. Without the full-fledged trial, one can be convicted.
No.
Then
he is not convicted, but he was taken into custody, and he was ultimately released on bail.
maybe that's why why release on bail? That has to be tested before the court of law. The prosecution or the CBI has to prove the case beyond all reasonable doubt, whether the case initiated by the CBI on the basis of which the charge sheet is filed is correct or not. If you are able to prove, then he will be convicted in terms of the provisions of the BNS or the CRPC or IPC, whatever it may be. Correct. If it is not true, he will be acquitted. Can you take the prima facie view? Yes, he will be convicted. That's why he will be debarred, or he will be. How you can do that?
This one point. That is kindly come to para 9.
Yes.
Para 9. 6. There is no scope.
Of NSPM 11, 12, and 22.
And 22.
Correct. Yes.
For dealing with situations arising out of the law. As in the present scenario, the sequence of so-called suspension and thereafter blacklisting as advocated in box 2.5 of NSPMs 12 and 22 applies to ineffectiveness or incompetency or non-compliance of and the same do not apply to criminal offences by the fumigator or fumigation. That is why the CBI was forced to compelled to take him into custody and cancel his license for free.
Cancel his license.
Actually, business, I mean, brand.
Kindly come to the 11. You are having the NSPM. What does 11 says? See from your mobile.
I can share
11, 12, and 22.
You won't be able to.
Where is your 11? I don't think any 11 in the NSPM.
22.
Huh? 2.5. 2.5. 2.5. 2.2.5 or 2.5?
This is
2.5, yes. Where it is mentioned that it is not applicable if the criminal case is initiated. This provision is not applicable, not withstanding anything contrary there to any.
No, it's not written like that in 2.5, but I'm saying that this 2.5 is not applicable in this.
That's why if it is not applicable, show me in this NS, it is your guidelines. It is your guidelines. Show me which provision it is applicable and which provision it is not applicable. Is there any specification criminal case? If the criminal case is initiated, no application of this memorandum or guidelines.
There is another thing, I'm trying to.
Yes. You argue on your own way.
Kindly come to 15.
15. 15 of the main petition. Yes. $15. Yes. Yes. Yes.
Certificate of registration granted shall be liable to be withdrawn or cancelled should the same fall in making false records or issue fraudulent certificates or fail to meet the requirements of the methyl bromide standard or violate any provisions of the Insecticides Act in 1968 and rules and regulations thereunder and thereunder. So, this is the point that relevant very much for this translation.
Yes.
And one more by Adam P. Or obligation here, page 7, para 6.
Page
7, page 6, page 6. Page 6.
Yes.
Finally, from the middle also.
Yes.
That the unit of exceed commodities of has
Page.
Page number 6.
Page number 6.
So I would say
first number 1.
Yes.
An international obligation having implications of trade and commerce, operation or pay of false study. Number 2, a national requirement as it is a means to keep Indian agriculture, environment and farmers safe. And number 3, a public concern as any non-destructive communication with extremely risky chemicals, that is methyl bromide NDR and aluminum oxide ALP, are amongst the most dangerous chemicals in agroforestry trade with very alarming publicity, and therefore the action or service provider is crucial. This is the
That's all? That's all? Thank you.
Order of
Citation to citation to
on the basis of natural, the principle of natural justice.
नामटा बोल दो
Which paragraph?
2003 9 SCC
Jalgaon Municipal.
Paragraph 30 to 30.
paragraph 31
30, 31, 30.
that would और এখন আমি চলে আসো হাতে
Thank you. Oh, no.
that I mean most of us faced it for last 2 months. I to faced it because in the winter of the AQI level becomes so high pollution. I face a lot of, and I'm a patient of asthma.
Yes, anything?
Just 2 sentences. Okay, just 2 sentences. Sentence number 1 is just to show the contradictions. Reason for banning is pendency of the criminal case. It's not effectiveness, lack of effectiveness in my fumigation at all.
That is not there.
Now, if it is effectiveness comes, then by the very same logic that NSPM that covers, these are the timings you have to give, which is, I don't think I should say anything else. This,
Hearing concluded, seal.
but the next is the identical.
Interim order is extended till the final order.
Both the matters.
Both are same.
Both
same. Item number?
19 and 20.
19 and 20.
But just one thing I just forgot. One page Lordship can take note that my page 34 of the reply, my validations, accreditations, which is a extremely melod assessment is done, that is up to 24th of July 30.
Validation.
Yes, that's there, page 34. And that is
July 30?
30, 2030.
Okay.
So purpose of saying this is that, in fact, this agency happens to be one of the best. There is no allegations of any lack of quality of us. Only thing is that
Criminal
that's the
case. Criminal case.
Deeply obliged.
Yes, next.
But I have kept my words. It was not a
Thank you. Thank you. Yes, next.
Lordship, I appear for the state. Not the matter as I appear for the petition and order of the affiliate authority under section 47B of the Indian Stamp Act.
Yes, yes, yes.
That was challenged.
Yes.
it appears from the said order as it appears from page number 151 to 154 of the real petition. That, my lord, a demand raised by the, my lord, the additional Director General of the stamp, the Deputy Inspector General of the registration. Demand was raised by the Deputy Inspector General of registration. My lord, with regard to, my lord, according to assessment, registration, execution done, but the registration was not complete because of deficit of, my lord, the stamp duty. Now, my lord, my lord, preferred under section 47B to the, my lord, that the appeal before the Commissioner of Bardhaman Division at, my lord, page 151, 154. It appears after going through this that, my lord, certain documents, my lord, my lord, could not, my lord, place before the, my lord, the appellate authority also. And that is why, my lord, that demand raised and, my lord, the order against which the appeal paper, my lord, that remains. Now, my lord, in course of hearing, my lord, they said that those documents are with them with regard to that certificate of that, my lord, that royalty that under the patent. Now, my lord, by way of supplementary affidavit, my lord, copies of those documents, my lord, they supplied to me. So my humble submission, if they are relying on this document and if they would bail out of this by producing those documents before the authority, let the original be produced before the authority and authority, my lord, direct authority to look into the matter afresh. So, kindly, my lord, it appears, my lord, may I tell, it appears at page number 153.
Yes.
That the shortcoming. My lord, at the middle, the second paragraph, on examination of the statement of above Schedule 1 and Schedule 2.
Containing the
my lord, the deed.
Yes, yes.
Containing the document, it appeared that the registration of the remaining 5 brands of labels were not included in the statement of registration as mentioned under Schedule 2. The parties would not produce any such registration at the time of hearing or thereafter at that level. Then the party could not produce any certificate of registration for the above brand and label with the seal and signature of the relevant copyright office. Now, then, my lord, the last part one, my lord, in the same page 153 paragraph, from all such observation and on verification of all the related documents as submitted by both the appellant and respondents, it appeared that document number 335 of 2015, that is the, my lord, the deed serial number, not deed number, serial number, in question was not entitled to get the benefit of exemption of stamp duty under Article 23, exemption list of Indian Stamp Act 1899, as the assignment was not done by entry made under the Copyright Act 57, Section 18, which was very rightly and justifiably pointed out in the audit para by AG. So, my lord, the demand raised an amount of 53,99,000 against which the petition filed. Now, my lord, in course of hearing, they said no. So those certificates in respect of the other items they possessed it. And my lord, they wanted to file a supplementary affidavit annexing those. Now, my lord, a copy has been served with me. Now, my lord, my humble submission, my lord, if they duly possess all those certificates, now let them place it before the, my lord, appellate authority at least once again, the original, and the veracity of them, let it be, my lord, checked and verified, because their satisfaction, after all, my lord, page number 153 and 154 is the, my lord, the order.
Yeah, that is the only reason you have not exempted that. The document is not produced.
From supplementary affidavit, copy of which my lord provided me, that those documents they have annexed here too. Copy of those documents. If that is so, if they produce the original, let them produce before authority concerned. That is my humble submission to you.
Yes.
My lord, my argument, my lord, on the first day when I moved the start, my lord, writ petition was that the assumption of jurisdiction by the authorities was beyond the, my lord, provisions of section 47A, which is a West Bengal amendment in the Stamp Act.
Okay.
My lord, kindly comes to, my lord, page, just for, my lord, a recollection, my lord, page 140, because this is going round and round, my lord.
I think matter can be today, matter can be, my lord, disposed of in this way. If my learned
No,
friend says-
I don't agree with deepest of respect to my learned friend, and I want to convince your lordship on this because my learned senior friend says, my lord, these documents were not there before the authority. My lord, these documents were there. I have annexed it with the writ petition, the letter, forwarding letter, the applications, the trademark, the copyright registrations. So, my lord, once they had it, my lord, the only ground on which they proceeded is that I have not disclosed the market value.
Correct.
My lord, kindly comes back to 140. This is the first order impugned, my lord, because this has been confirmed by the appellate authority's order.
Yes.
My lord, 140, my lord, kindly sees at the heading, my lord, just after sub rule 5 of rule 5, notice determination of market value under subsection 5 or subsection 8 of section 47 capital A of the Indian Stamp Act.
Correct.
So they are invoking 47A.
Correct.
And my lord, kindly sees the body of the, my lord, notice this order. In continuation of the notice so and so, my lord, I am skipping the first few lines. Where proper stamp duty is payable on the basis of the market value or settlement or transfer of lease by way of assignment, and in respect of which statement in Form 1, Form so and so, was furnished before the registering officer of AR3 Kolkata, Office of the Registering Office on Atto has determined by me at rupees 9 crores.
Correct.
So market value determination,
9 crores.
9 crores. On what basis does the, my lord, authority find this? My lord, kindly, my lord, compares this with page 21. 3.1. So I disclose, my lord, in my agreement for assignment of copyright 9 crores.
Correct.
And 9 crores is what the authority comes at. Then, my lord, authority says, you are hereby directed to pay the sum of rupees so and so, my lord, the sum is indicated later, into the government treasury, or to pay the sum by a bank draft drawn on so and so. My lord, the sum, kindly see, stamp duty payable is 54 lakh, less stamp duty paid is 300, deficit stamp duty is 53,99,700. Now this entire order of the first authority, which proceeds on the premise that jurisdiction is assumed under 47A, according to me, was wrong. And my challenge before the appellate authority was in this regard. Now, my lord,
Appellate authority has considered
my lord, nothing. And my lord, lordship kindly takes note of one document also, my lord, because my learned senior friend said these documents were not there, page 40 of my writ petition. And lordships are aware, lordships had been, my lord, dealing with, my lord, intellectual property matters also, my lord. Copyrights per se do not require a registration, my lord.
They produce before the authority.
My lord, I have produced. I will compare each and every document which is there in the supplementary also. Because, my lord, I had produced it. Page 40 is my covering letter. It is an application, my lord, sees the, my lord, reference. Application on Form 15 for registration of changes in the particulars of the registered copyright. So this is the, my lord, forwarding letter. Now, my lord, kindly takes, my lord, one by one, my lord, from page 44 onwards. 40, my lord, 41 is, my lord, first, my lord, copyright, my lord, registration certificate in respect of Rasoi Limited, my predecessor.
Yes.
My lord, I have marked each and every pages, my lord, all the, my lord, documents, my lord, whatever was there, my lord, certificates up to page 133 were disclosed with the Register of Copyrights. Now the, my lord, stamping authority who is saying that there has been an undervaluation, my lord, according to me, my lord, this is contrary to the amendment. Kindly takes West Bengal, my lord, amendment, my lord, section 47A. My lord, I'll give a copy. I had given a compilation, my lord, where, my lord, 47, my lord, the Stamp Act provision was there. My lord, kindly takes that compilation.
Yes. Rule 13.
47A, my lord. Compilation page 2. It should be, my lord, page 2 of the compilation.
Yes, page 2. 47.
Yes, my lord. আমি দিয়ে আপনাকে দিয়েছিলাম দিয়ে দেব instruments of conveyance etc undervalued.
Correct.
How to be dealt with? Now the order does not say undervaluation. Where the registering officer appointed under the Registration Act has, while registering an instrument of, my lord, the nature of instruments are mentioned, kindly, my lord, takes, my lord, just after that, reasons to believe that the market value of the property which is the subject matter of such instrument, has not been truly set forth in the instrument presented for registration. I pause here for a moment. Market value of the property, which is, my lord, the copyrights, have been set forth in the agreement. It is 9 crores. My lord, the order at page 140 does not say that the registering officer is of the opinion that the market value of the property has not been truly set forth in the instrument. He may, after receiving such instrument, ascertain the market value of the property, which is the subject matter of such instrument. My lord, to invoke 47A, you have to first hold that the, my lord, set forth value in the agreement is something which is not the market value of the subject matter of that agreement. That finding is conspicuously absent.
So the first authority, registering authorities, only stated that they have not paid the total amount.
Yes. Now, how did the registering authority assume jurisdiction under 47A? My lord, I showed the, my lord, heading, two provisions, 47A5 and 47A8 were referred to. Yeah. Lordship comes back to, my lord, once at the cost of repetition, my lord, page 140. Lordship will find two, my lord, provisions quoted there.
3 does not make a payment of stamp duty.
No, my lord, just at the top, my lord, just beside the date. 11th October 18, just beside that left hand side, notice determination of market value under subsection 5.
Where you?
My lord, page 140.
140.
My lord, writ petition, page 140.
Yes.
My lord, just at the top after the memo number.
Subsection 8 of section 47A.
And subsection 5.
Correct.
Subsections. Now, my lord, kindly takes back the, my lord, compilation.
Page 347.
My lord, it should be internal page 3 of the compilation.
Correct. Yes, on receipt of the reference under section
under
3.
Subsection 3.
Correct.
So, my lord, subsection 3, now, my lord, see subsection 3 of 47A, where concerned person does not make payment of stamp duty as required under subsection 2 within this time specified in the notice. This was never done. My lord, subsection 1 has to be first invoked. Registering officer has to come to a prima facie finding that the set forth value is wrong. Then, my lord, they will determine what is the deficit. Then, my lord, subsection 2 envisages where the market value of the property, which is the subject matter of an instrument, has been ascertained and proper duty chargeable thereon has been computed under subsection 1, registering officer shall, in the manner prescribed, send to the concerned person a notice calling upon him to make payment of the deficit amount of stamp duty. My lord, 5 comes much after 2 and 3. 2 and 3, 1, 2, 3, 4 never followed. You straight away come to 5 without following 1 to 4. Your assumption of jurisdiction under 47A5 is absolutely dehors the provisions.
Okay. So your submission is that you have already disclosed the value and he had not ascertained whether it is correct or not. Only stated that it has to be paid. He has invoked the provision of section 5.
Yes, my lord, I had relied upon the judgment.
Correct, that is there.
Yes.
Yes.
And my lord kindly takes also the appellate authority's order. This is, my lord, not discussed by the appellate authority.
Appellate authority has gone on another.
So, my lord, lordship is testing the appellate authority's order on the basis of the findings written by the first authority. If the first authority order goes, my lord, beyond jurisdiction, then, my lord, the appellate authority is as a consequence must go.
Okay.
And, my lord, so far as, my lord, no payment of that rupees 300 is concerned, law, my lord, Stamp Act permits that.
That is
300 is what the Stamp Act says. It is by entry into, my lord, copyright. And I had, my lord, taken the liberty of relying upon a copyright board judgment, which, my lord, discussed the law. Because the, my lord, that judgment said it is really a surplusage. Lordship may take note of that judgment once again. One paragraph I had relied upon in my opening submissions.
Have you provided that?
My lord, I had, my lord. My lord, this was a copyright board judgment. Bharati Datta versus Sharadindu Basu, my lord. It was a 2008 judgment. My lord, I have another copy if lordship wants, my lord.
It is not here. Give the copy.
My lord, I'll give another copy.
Yes, sir, Bharati Datta.
My lord has that.
Bharti.
My lord, I had cited paragraph 17, my lord. Part of paragraph 17, my lord. This should be, my lord, page 24, lordship will have.
He has argued.
Yes, my lord. Middle of the, my lord, paragraph, it is cardinal principle of interpretation. Lordship has that.
Page.
My lord, this
24.
should be, my lord, penultimate page of the judgment. 24.
Yes.
My lord, leaving the first 8-9 lines, we proceed to deal with. we proceed to deal with the argument of the counsel for the respondent that these conveyances, even if those are taken to be in the nature of assignments under Copyright Act, do not enjoy the benefit of exemption and provided. Yes, my lord. So it's a surplusage, my lord. Now, if the registrar of copyrights does not, my lord, incorporate that because the, my lord, valuing authority is not doing it, my lord, I am in a, my lord, vicious circle between two authorities.
Okay, thank you.
Grateful, my lord.
Reply to the sir, kindly give me
No, my lord, this I replied, my lord. I have been waiting, my lord. Lordship, in fact, noted that this is 2022.
This, my lord, argument was not advanced on the very first day.
Lordship has the note of it.
I think first day you're not there. He has argued the matter. Second day you came.
Now, my lord, on the second day when I appeared, my lord, then if my learned's contention is that all the documents were already, my lord, before the appellate.
No, leave aside the all the leave aside the all the document. I am not on leave aside. Kindly see 45A subclause 8.
Yes.
Correct. In their application, there is already disclosure of 9 crore. That is not disputed. That has not been disputed by the registrar.
Yes.
Only the registrar stated 9 crore. The total stamp duty is to be 54 lakhs. He has paid only 300 rupees. So that's why the 53 lakhs, some odd amount is required to be paid.
First of all, my lord, there are two sets of valuation. One set is that, my lord, the total value of the, my lord, the property or the, my lord, the royalty. Second is that, my lord, with regard to exemption.
No, that
should be the exemption.
no, exemption will come because that's why exemption. So he has stated that he is not entitled to exemption, only paid the 300 rupees, pay the 53.
Basically, their demand is that they are covered because of the, my lord, the exemption clause. Now, my lord, the authority and the appellate authority both say that certain documents they
No. Registrar has not stated. Registrar appellate authority has gone on the wrong way. Kindly see the registrar order. He has not stated that he has not produced the document. Kindly see.
140.
140 is something else and the appellate authority has gone something else. See?
No. I am getting rebuked.
This, my lord, the
Because your registrar has not gone into that. Yes, there is no document, valuation is dispute and is not. But the appellate authorities have gone some other way.
No, that is, my lord, from page 139.
140.
139 and then
Yes, 139 is a notice.
Yes. That is also the 47. That is under 47A. For
Yes.
the determination of correct amount of stamp duty payable by you.
Correct.
After that, this.
This.
Then may I tell, madam, may I, lordship kindly, madam, give me, because I thought that matter can be remanded because of this matter. So kindly give me, madam, another.
The London Council for the petition has concluded his argument. London Council for the state press for time to give reply only with regard to the legal point. Accordingly, case adjourned. Let the matter appear on 12th March within 3 matters at the same heading.
Very grateful, my lord.
12th March?
I'm grateful.
13th. 12th is a Thursday.
Friday the 30th, I would wish to avoid, my lord. Help is good. Maybe lucky for you.
Yes. 12. 13.
Very
Okay, 13 kari. Within 3 matters. Huh? 13.
My lord, 29, I am appearing for the respondent bank, my lord. I apologize for appearing virtually, my lord.
Yes.
Nothing to say. Well, our contention was relying on, as my lord has suggested, the Bombay High Court judgment, that nexus has not been proved, but an account has been seized. As till now, there is no disclosure. One disclosure in the affidavit, or so-called, my lord, the nowadays report. It said there was a transaction. A check was given to me. I given a check to that account, and that was returned to me. It has nothing to do with the crime at all.
Who is appearing?
My lord, I am for the respondent bank, my lord. My lord,
Yes.
on the last occasion, your lordship has directed them to serve a notice, fresh notice to respondent number 5, my lord.
Be sure about the service. The
That's
Scandal police station, your lordship specifically said.
My lord, may I assist my learned senior, my lord? Your lordship's order is also can be placed as a reference, my lord. Your lordship in WPA 29593 of 2025, Adarsh Autobahn India Private Limited also has dealt in the similar matter, my lord. The order dated of 24th December, my lord.
আমি আগে
नो रिस्पॉन्स कोई ऑनलाइन है कोई ऑनलाइन আছে कोई कोई प्राइवेट पार्टी या कोई दूसरा कोई ऑनलाइन है कौन है हाँ? वो तो है दूसरा नहीं है पंजाब से कोई नहीं है
Anand, someone K. Sharma is appearing, my lord. I don't know whether he is for this matter.
Okay. Yes.
That is the point, man. Your lordship earlier order. That was that if they don't appear, your lordship will dispose of this matter, and disposal to that extent relying on your lordship's court judgment, Bombay High Court judgment, and Supreme Court judgment also.
You have a copy? You have a copy of the judgment?
Yes,
yes. Where is your freezer order? Where is the document?
Referring to the Bombay Calcutta first, then Bombay will come. Can you come to Justice Bhattacharya's order, page 3?
Yes.
The Honorable Judge has quoted one of section 102 of CRPC
Correct.
and said must have a relatable nexus with the commission of offense. That's the main thing.
Where is the freezing? Freezer.
Yes. Will kindly come to page 76.
76.
Yes. 76. Nothing disclosed, no reason.
Current account, Commandant Order Limited. No debit by the bank due to the instruction issued enforcement agency of Karnal.
And
yes.
FIR also you have an act. There is no disclosure of this.
The petitioner has filed the present application praying for a direction upon the respondents to defreeze the account of the petitioner maintaining with the HDFC Bank Limited, D and capital D capital N dash 1, Eternity Building, Salt Lake Sector 5, branch, being current account number 502 000 5964 1491. The petitioner submit the petition is maintaining current petition is a business. Petitioner is the company or the personal?
Company. This is the company.
Petitioner is a company. And maintaining the current account with the HDFC Bank. HDFC Bank. When your account was freezed.
27th of June 2020.
On 27th of June 2024, the account of the petitioner have been freezed by the bank. And the bank has informed the petitioner that the account of the petitioner has been marked as no debit inward comma, pursuant to the direction received from the law enforcement agency, Karnal, within bracket Haryana, in relation to complaint / FIR number 37 dated 2nd June 2023 under section 419/420/120B of the IPC. Full stop. Accordingly, the petitioner filed the present writ application praying for a direction for defreeze the account of the petition. Full stop. This court find that the bank from the communication, this court find that by a communication dated 24th of July 2025, the bank has informed the petitioner with regard to mark the account of the petitioner not debit as per the direction received from the law enforcement agency Karnal. Full stop. By an order dated
18th February.
you have made a party.
9th February.
The petitioner, you have made a party. The petitioner has made the station
Service affected.
has made a party to the station house officer, Cybercrime Police Station Karnal, as respondent number 5 in the present case. And according served the notice to the respondent number 5, but in spite of service of notice, the respondent number 5 has not appeared. Accordingly, by an order dated 18th February 2026, this court has further directed the petitioner to serve the notice upon the respondent number 5. And in compliance of the said order, petitioner has sent again sent a notice, which was duly received by the respondent number 5. But in spite of receipt of the notice, none appears on the behalf of the respondent number 5. Full stop. In the order dated 18th of February 2026, this court has made it clear that in spite of the receipt of the notice, the respondent number 5 failed to appear before this court or to file report. This court will dispose of the writ application without giving any further opportunity to the respondent number 5. Full stop. The respondent bank has recorded the account of the petitioner has no debit only on the instruction of the law enforcement agency of Karnal, Haryana. But in spite of the service of notice, none appears on behalf of the law enforcement agency. It is settled law that unless and until the investigating agency not obtain any order from the learned court wherein the case is pending under section 107 and 106 and 107 of the BNS to freeze the account of a particular person, the law enforcement agency cannot direct the bank to freeze the account. In the present case, neither the bank nor the investigating agency has produced any document to show that the investigating agency have obtained any order from any court for freezing of the account of the petitioner. Only an FIR has been initiated. That is also not involvement of the petitioner, the investigating agency has directed the bank to freeze the account of the petitioner. Considering the above, this court find that the freezing of the account by the bank only on the instruction of the investigating agency, though the investigating agency has not produced any document whether they obtain any order from any court of law. Accordingly, this court is of the view the freezer of the account on the instruction of the investigating agency is not in accordance with law. In view of the above, the bank is directed to immediately defreeze the account of the petitioner and the petitioner to allow the petitioner to operate the bank account immediately. No, that is CRPC BNS 102 CRPC BNS.
Malad, this notice is also under CRPC, Malad. This proceeding under CRPC, Malad. This proceeding is under CRPC.
Let they come. The bank has filed the report alleging with regard to some transactions, but the petitioner has dealt with the said transaction. This court has not gone into merit of the same, as the investigating agency has not come forward whether this account is involved in any criminal case or not.
Grateful, Madam.
Disposed of. Yes.
And if you Mr. Basu, then Mr. Basu does not treat, he is the secretary of the.
No, no, he has given, he will treat, he will. What? Ah. So it is not at to the 3 p.m. It is not listed. Yes. You, huh? The sleep is not there. What is the urgency? Good. ट्यूसडे को ही देंगे इसको अर्जेंट मोशन में रखो अर्जेंट में 4-5 का मैटर में रख
Grateful, man.
It's leave to mention a matter. I know it's not the time for mentioning. I know it is not the time for mentioning, but if your lordship so allows, but it is a matter not in your lordship's list, but the affidavits have been exchanged. It is ready for hearing. Your lordship could, I'm mentioning upon notice, if your lordship could fix the matter, I know it is.
Other side.
But I've given notice. I'd served notice on the advocate itself.
With the other side come, then you can fix.
But they will not.
The other side will say, I have no knowledge, then fixing no purpose would be served.
If your lordship fixes the matter, then I'll serve notice immediately saying that your lordship.
Monday mention, I will give the list along with the service notice. I will see to that.
Very well. Okay.
Yes, call the
Great.
My application.
The time to file my opposition, your lordship. By 2 weeks.
Order granted by lordship, which is expiring. It is granted till today.
Can be extended, your lordship. I have no.
You know objection.
Yes, no. Actually, I don't have any.
Yes, recorded on. Though the matter is specially fixed today for hearing, but the lender counsel for the respondents prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within a period of how much time?
4 weeks time, your.
What is the difficulties, my lord? North Eastern Front Railway, my lord. We have tried to contact with them.
4 weeks. 4 weeks.
4 weeks.
Within 4 weeks, reply if any.
4 weeks, my lord.
Reply 2 weeks thereafter. 2 weeks thereafter. List the matter on. Give the date. April की order है. May में रख दो. 4 weeks, 2 weeks, 6 weeks, na? After 6 weeks. So today we are on 6th April. 1st May at 2 p.m. 1st May at 2 p.m. As a specially fixed matter, interim order is extended till 4th of May 2026 or until further order which of this. Wait for it.
Lord, apart from this matter, my lord.
Hey, 1st May is holiday. 1st May is holiday. Not made a Buddha Purnima.
No, for us, it's not. High Court is not a holiday anymore.
Not holiday.
As far as I know. Oh, this year I think it is.
This time,
Yes,
this is
Friday. Friday is a holiday.
4th May. 4th May, interim order till 7th May or until further. Yes, next.
I am appearing for the petitioners, my lord. 30 to 34 are analogous. Core issue is same. Petitioners are different.
30 and
30 to 34 months.
30 to 32.
Yes, 34. All 5 matters are analogous. The issue is the same.
Yes.
My lord, I will just first place the issue in very short. The basic issue, my lord, in all these petitions is that a show cause notice has been issued under section 8(1) of the PMLA Act. We have repeatedly asked for the relied upon documents by the department, which have not been provided till date. Thereafter, we went up to the learned adjudicating authority. We applied for certified copies of whatever records they have regarding the case. Those have also not been provided. Now, my lord, in these situations, they have fixed the date on 9th of March for hearing of that particular show cause notice without passing any order. And there are multiple procedural violations throughout, my lord. I am not taking your lordship to the merits of the facts. I will just put before your lordships why this whole procedure, my lord, is actually become a fallacy.
When the show cause was issued?
My lord, the show cause was issued on 25th of November 2025.
Where is that?
It reached us, my lord. I am coming. Kindly give me a minute. My lord, kindly takes up there are 5 writ petitions, my lord. Kindly takes up the first one, 5043, man. Because actually it has been filed in 2 batches, 5043, 5053 and 5094 were filed together, one after the other. Then, my lord, came this 5199 and 5200, which were filed with urgent leave, my lord. So, my lord will kindly come, your lordship, to the show cause notice, which was issued on. It is at P18, my lord.
P18.
P18. Oh, no. My lord, I beg your lordship's pardon. I beg your lordship's pardon, my lord. 1311, 611, 2511. Time direction. No, কিছু বলেন। সোমবার দিন হিয়ারিং আছে। I need to just add interim stay. না কি করে stay? P6. My lord kindly comes to P6. Page 58 of the.
I will issue a direction to the all authorities not to fix any short date to giving burden upon this court. I will run.
My lord will kindly appreciate. Yesterday, I am technologically handicapped. I got scanned copies at around 10:30 in the evening. So when I'm trying to come to this page, I'm losing the track of the other page. So basically, I'm briefless today, but their urgency is there, millet. So I cannot.
Yes.
The best I can.
My reliefs are not against the Union of India.
Page.
My lord, kindly.
I am not Union of India. I am Enforcement Directorate, sir.
Oh,
I am better known for Enforcement Directorate Council.
Now he is the top in headlines of
in
India.
My lord kindly comes to page 58, P6 of volume 1, my lord.
58.
58, my lord. The lordship will find 5043 page. Page 58, my lord. You will have found that intimation of notice to show cause.
Yes.
Yes, my lord. Your lordship.
27 November.
My lord.
No, 27 November.
Yes, 27 number. This is the letter of the registrar of PMLA, the adjudicating authority. Now, my lord, this has got the show cause notice at page number 67. But before that, my lord, I take your lordship there. Kindly seize the first paragraph of that letter. Why I am saying this is perverse. My lord, above, if I may read out, my lord. Above named applicant has filed an application under subsection 4 of section 17 of PMLA, wide e-filing reference number so and so dated 8/11/2025. My lord will kindly note. Inter alia praying for the retention under section 20 and 21 of PMLA of movable properties in the form of cash, digital devices and documental records seized on 10/10/25, 11/10/25, 28/10/25 and 29/10/25. And the same has been registered as OA number 351 of 2025. Now, my lord, I just stop here for a moment. This petitioner, my lord, suffered the search and seizure on 10th and 11th. Other petitioners in other matters also suffered on 28th and 29th. But why I am saying, my lord, that this whole process is perverse. Now, this is what they say, that they have filed an application under section 17(4) on 8/11. Now, my lord, why is this date important?
Who filed the application?
My lord,
who is the applicant?
Deputy Director, the ED.
Who is the applicant?
My lord, Vibhuti Bhushan, Deputy Director, my lord, on that particular intimation notice, my lord, at page 58, your lordship will find up top. He is the Deputy Director.
Deputy Director.
Yes. So he has filed the particular application, my lord. My lord, this comes out of Bear Act. Both the Bear Acts. Act file. My lord will kindly give me a minute now. Bear Act. My lord, if your lordship will kindly have the act, my lord.
What is your prayer?
My lord, my prayer is a very short stay so that they provide us the relied upon documents and so that we can reply to this show cause notice. My lord, kindly takes up 17(4), my lord, section. What they have to do? That is the timeline. We are actually running against the timeline. We have been after them for months. That please provide us with the documents, please provide us with the documents, please provide us with the documents. Kindly takes up 17(4), my lord.
the authority seizing any record or property under subsection 1 of freezing or any record or property under subsection 1A shall, within a period of 30 days, they have to prefer the application. Now, I ask myself, can they circumvent this? This is in the principal statute. Now, kindly takes up the rules. Rules, starts at the procedure before the adjudicating authority, The rules come at page number 138 of the same book.
Yes.
This is the adjudicating authority procedure regulations of 2013. Now, kindly comes there in to rule number 13 at page 141.
Yes.
Will see issue of summon and notice. Every summon or notice shall be issued in Form 3 or Form 4 or Form 5 or so and so,
Yes.
as the case may be, and signed by the registrar or administrative officer. Every summon and notice shall be served by the complainant or applicant.
Yes.
Upon the defendant or respondent, along with complete relied upon documents. Now, my lord, this is the core issue. Complete relied upon documents in a bound paper book and an affidavit of service along with proof of service shall be filed by the person affecting the service. So I have a right,
yes,
as a noticee, my lord, to get this.
Yes.
Now, my lord, what has happened on the facts? This is the basics of my case, my lord.
Yes.
This is where I am standing. Now, my lord, what has happened on the facts? My lord, kindly takes up. I have just given a chronological list, so it will be very easy for your lordship to catch on. My lord. Kindly sees what has happened. My lord, kindly takes up my writ petition at paragraph. At paragraph 10, my lord. The writ petition at page 7, paragraph 10.
Yes.
My lord sees that the history of this case starts in 2023. Municipality scam directed by this honorable court, my lord. CBI takes up fresh investigation. Fresh case of ECIR has been filed. Now, my lord, kindly turns over. Kindly comes to the second date, my lord, 10/10/2025. He searches page 8. I'm paragraph within writ petition. List of dates. Paragraph page 8 of the writ petition. Kindly sees 10 and 10/10/2025. I suffered the search and seizure. 17/10, I submit a letter saying that please give me some time to documents, because they had given verbal directions during the search that you have to submit these documents, so and so forth. So, my lord, these letters are all annexed. I will take the lordship if needed to that letter. On 23/10/2025, my lord, voluminous documents are submitted to the ED. Whatever they have asked for at that particular point of time. Thereafter, my lord, on 31/10, this petitioner is issued a summon under section 50. 14/11 or 4/11, the petitioner had also appeared, and then the sequence continues. Now, documents have been submitted which have not been brought on record. Seizure, whatever they have seized from me, those have not been brought on record. No, they have not been brought on record. Whatever documents as per rule they should have impounded. Time to time, we have gone on giving them documents which runs to around 40,000 pages. Nothing has been brought before the learned adjudicating authority in the proceedings. Now, my lord, why we are aggrieved? My lord kindly takes up that particular page 56, where I had taken your lordship in the beginning. The notice, the letter of notice that was served on me, my lord, will kindly see. 58, my lord. Kindly comes to page 58. This is the letter.
Yes.
Now, behind that letter, my lord, from the next page, the lordship, there is an instruction which is given for both the parties, the petitioner also and the ED also,
yes,
by the adjudicating authority, that we have to follow this procedure.
Yes.
Now, my lord, kindly comes down to the middle of the page, my lord.
59.
My lord, page 59, middle.
Hmm.
The lordship will find there is in bold italics. My lord, they have justified why this time-bound thing is required. My lord has got it?
Yes.
Necessary, as sometimes unnecessary doubt is raised, there is a gap between pronouncement of order and so and so. Thus, the authority is left with approximately 70 days to complete the proceeding. After submission of reply by the defendants, availing minimum of 4 weeks from the service of notice 8/1, 4 weeks time is given to the complainant to submit the rejoinder. Thereafter, the hearing for the final arguments is held within 24 weeks. 2 to 4 weeks of submission of rejoinder. This leaves the authority a cushion of 2 weeks only in course of proceedings to grant adjournment, and this means more than a week is adjournment can be granted. Otherwise, each party, keeping in view the aforesaid, my lord. Now, this is important. In case documents are required, the requisition for the same is to be made within 7 days of the receipt of the notice under section 8(1) of PMLA 2002. To the complainant with a copy to the registrar adjudicating authority. The ED is required to make available those documents within 3 days of the receipt of the requisition. In case, for any reasons thereabove, the documents cannot be made available, the complainant is required to inform the defendants in writing within 3 days of the receipt of the requisition. So I make a requisition to ED man within 7 days of receiving the notice.
When you receive the notice?
My lord, we received the notice on 8th of December 2012.
8th December.
Yes, my lord. And that is at 8th of December 2012, my lord, we received the notice, my lord, that we have stated that notice.
2000?
My lord?
8th of December 2000?
My lord, 8th of 2025. I am sorry. 8th of December 2025. We received the notice.
Yes.
This letter, my lord, that what we have, your lordship has seen. So, my lord, kindly turns back to page 58.
That is a page 58.
My lord, page 58. But kindly sees the bottom. There is a stamp on the left side. This is an advance copy without the relied upon documents.
Advance copy where?
Without RUD. RUD means relied upon document.
Where?
My lord, at the bottom left side, my lord, big in bold. This is the page, my lord, I am referring to, page 58. Here, my lord, on the left side, advance copy.
So cause of the chairperson / member.
Given under my hand and seal, my lord, last paragraph.
Given under my authority and the second.
And then, my lord, it has come this part.
Yes.
That is, therefore, that rule 13.
Advance copy without.
Advance copy without. Now,
what is RUD?
RUD is relied upon documents. Now, my lord, first violation of rule regulation 13. This comes through. RUDs do not come. Now, without the RUDs, whatever it may be, I am instructed to, my lord, seek required documents from the ED, which they have to supply to me within 3 days. Now, my lord, whether I have satisfied that or not.
So this one you have received on 8th of December.
8th of December, my lord.
So when you are requested to supply the document?
My lord, we have requested on 15th, my lord. That letter is at. Kindly comes, my lord, to Annexure P7. My lord, page 70.
Yes.
My lord, this petitioner received this particular notice, my lord, on 10th of December. So, sorry. My lord will kindly. So, I send a requisition, my lord, within 7 days. That please give me these required documents. This is Vibhuti Bhushan to the complainant, my lord.
Yes.
From Deepak Dev, which is the petitioner.
Yes.
Now, your lordship will find that we have given the details of the things in attachment, my lord. That attachment, the whole detail letter is just thereafter from page 72. What are we requesting? At page 72.
Page 72.
Yes, that is the letter, what we requested. My lord, comes to page 73. Yes, my lord, the first paragraph in page 73, my lord, my copy is a bit illegal. It is stated that the RUDs have not yet been received. Your lord, you will find page 73.
Yes.
My lord, second paragraph. As on date of this letter of requisition, as per rule 13 of this one, so. Therefore, thus the following documents are being requisitioned to effectively defend.
My lord, leave me for just 1 minute and I am coming back. I apologize.
Yes, is no problem. You go. 73.
73, my lord, page
Yes.
73. Your lordship, we give a list of the requisitions without even knowing what they have.
The following documents being requisition for the effective defense of the case.
Yes.
Correct.
So and so, my lord. So details and true copies of information in your possession on the basis of which, along with reason to believe, recorded in writing. Because, my lord, this has got inception in section 17, the search and seizure. So whatever they have relied upon before even coming to search and seizure under section 17(1), which is called the RTB, my lord, that is the short form, reason to believe, we had not yet received. So we say that please provide us with the reason to believe and the further documents, that information which was in your possession, for which you have committed the search and seizure, and in consequence of which we have now suffered this section 8(1) notice. Now, my lord, this goes to them on 16th. Admittedly, we have sent them by speed post. We have sent them by email also. Now, my lord, kindly comes to page 77. This is the reply of the adjudicating authority. My lord, will see to our email and the letter on 18th of December, my lord, they say this they are directing to the ED that for your necessary action with a proof of service to be sent by 19/12/2025 on the email of the authority. This is in terms of that instruction, my lord, I had shown your lordship at page 59 that within 3 days, 7 days, I have to put it. They have to reply to me within 3 days. So 16/12, I have sent the requisition. 19/12, they have to serve to me.
Yes.
Or otherwise, if they are not able to serve, they have to give in writing why they are not able to provide me with the document.
16, then they have issued the on 18.
18, they have given direction that please give them.
Correct.
On 19th.
Yes.
Now, my lord, on 19th and thereafter, nothing comes. Now, your lordship kindly turns over and comes to.
But no documents out.
No documents comes. Nothing comes to us. Now, my lord, kindly comes to page 79.
Yes.
We give reminders, my lord, one after the other.
Yes.
Please give us, please give us, please give us.
Yes.
And your lordship will find your lordship on page 80.
Yes.
Your lordship will find that we have clearly written appears to have not been complied with. That the direction of the learned adjudicating authority appears to have not been complied with, and ED has no documents has been received till date.
Yes.
Now, my lord, this is now your lordship kindly turns over and finds this is a copy of, there are 4 annexures here. This is what we received on a USB drive. These next 4 annexures. One, allegedly a copy of an original application. Which date filed we do not know, but I will show your lordship. The notice said that it was filed on 8/11. Now, my lord, first comes the original application. Then there is something of a PDF file called RUD1. The second PDF file called RUD2A. Third PDF file called RUD2B, and one PDF file called RUD3. Comes in a USB drive. From whom it comes, with that same letter of the adjudicating authority, we have given the receipt on that, but we don't know who sent it to us, whether the adjudicating authority sent it to us or whether the ED sent it to us. Now, what is the perversity in this, my lord? My lord, kindly comes direct. I'm not going into the merits at this juncture, my lord. It's not required. Your lordship kindly comes to page number, my lord. Kindly comes to page number 137 straight away.
Yes.
My lord, will find that the prayer, what they are asking for. Lordship has got
138.
137. Page number 137, your lordship has got.
Huh.
That is the end part of this particular so-called application.
No.
Well, this is volume 1, page 137.
137, but this is a representation. Assistant Director PMLA.
Page 52 of the OA. Volume 1, your lordship is looking at.
Yes, volume 1.
Well, may I assist your lordship, my lord? I am very sorry if there is something wrong. Maybe this other brief or brief of the ethos. আমি কি অন্য brief নিয়ে নিলাম ভুল করে? No, this is also the okay. These are all photocopies only. All the other pages are matching your lordship. And this is 132. This looks at page 132, man. Most probably my copy would have been wrongly numbered. You know? My copy is the similar. So our copies are wrongly numbered. documents. I have to unconditionally beg your pardon, my lord.
Yes.
So these were filed in urgency. My lord, page 132, the lordship will find that prayer is there, my lord.
Yes.
Now, my lord, kindly sees the signature. The complainant, Vibhuti Bhushan. Now kindly sees the date.
13/11.
13/11. Now, my lord, the notice says this was filed online on 8/11. So, my lord, I ask myself, this has been served upon us. This is what we have got. Notice at page 58. On 8/11, your lordship.
Yes.
Now, first is this. This is one part. 13/11 comes out. Second, your lordship, I will place before your lordship why this has happened. I went personally for inspection of the documents to the learned adjudicating authority in Delhi.
Yes.
What I found, my lord, is that on 20th/11/2025, they had uploaded this document as a corrigendum. And I am saying this, my lord, as an officer of the court.
When?
On 2011, that is there in the record of the adjudicating authority. So we made a certified copy saying that give us the details of the files on which date they have been uploaded. They did not. They just outrightly denied the certified copies we have, applications we have annexed with this. So 2011, he comes in with a corrigendum, directly violating the provision of section 17(4). He had to file within 1 month, my lord. There is no provision or amendment or anything. And no order has also been passed accepting this corrigendum or whatever we have been supplied to us.
What corrigendum?
My lord, that is there in their record. Their record shows, the learned adjudicating authority's record shows, my lord, that there was corrigendum was uploaded on 2011/2025. Probably this particular document.
What is a corrigendum?
My lord, that is not given to us. We are asking for the same. They have not been given to us. That is one of the prayers we have made, my lord. Those certified copies should also be given to us.
So when this OA was registered?
My lord, as per them, this OA was registered on 8/11 within that 30-day deadline. 10/10 they have 10th of October they have committed the search.
The same has been registered as OA 351 of 2025.
My lord, on 8/11, page 58, my lord.
Correct.
And this is signed on 13/11.
Yes.
So this is prima facie, my lord. Your lordship can see what is going on. Who is uploading, when he is uploading, what version is being changed, we are not aware of. What copies are being given to us?
Yes.
What exactly the learned authority is considering without passing orders?
Yes.
There is no order on record that this particular 13/11 dated application was accepted by the adjudicating authority, that or it has been considered by the adjudicating authority.
Yes.
Nothing on record. Now, my lord, kindly sees. This part comes to us on 24th of December, my lord.
Yes.
So these are whatever they say. Now, my lord, kindly takes up. I will take your lordship to volume 2. Index table. Kindly takes up, my lord, that what is the sequence of events, what has happened. For this petitioner, your lordship, during the search and seizure, an amount was seized. 25.5 lakhs were seized from the residents. Whatever reasons they have given in their RTB or whatever it is, my lord, I am not going in facts right now. But we had given them on 23rd of October the whole invoices, GST returns, supporting documents, whatever they have asked, that how that amount landed up with me in my residence. Nothing was brought on record. That we have pleaded in our writ petition specifically. But now, my lord, kindly sees these documents which have come. RUD, they are saying these are RUDs. Now, these RUDs, my lord, I have made a index of the RUDs. This index of the RUDs, what we have been given. My lord will kindly take a volume 3 once. What has been given to us as RUDs?
Page,
my lord, volume 3, my page is, my lord, 370. Your lordship will kindly have a look once.
370.
370, my lord. This letter starts earlier.
Yes.
My lord will see there is a table. This matches, my lord. Yes. For once, my lord. This matches, my lord. For once.
That is starts from the serial number 1, 11th May.
It starts from serial number. But before that, my lord, kindly for one moment, my lord, kindly comes to page 365.
Yes.
My lord, this is the metadata of the files which we received on the USB drive on 24th of December. My lord, kindly will see the first file, which is admittedly the copy of the original application, which is again signed on 13/11. That shows, my lord, it has been created on 24th of December 2025. My lord, middle of the page below, bottom. The lordship has found modified on 23rd of December, my lord, and created on 24th of December. Why? How come this information is coming? Who is manipulating what document, my lord? We don't know.
Where,
my lord, at the bottom, my lord, first file is written like this, my lord. Kindly see.
It's not legible.
My lord, kindly takes my copy.
Modified 23rd December.
Yes, modified 23rd December.
Yes.
Now, my lord, allegedly this application was uploaded on 8/11/2025. Why would this file come, which is signed on 13/11 to us? That is one part of the thing. Now, my lord, kindly turns over. Kindly sees what is happening with the next file. There were, my lord, admittedly 1, 2, 3, 4, 5 files. Original application copy, 4 RUDs. Now, my lord, kindly comes over and sees the RUD 1 file. On the next page, my lord, 366.
Yes.
Yes, my lord, will find, my lord, again created that 24th of December, then modified 8th of November 2025. So this admittedly probably is the original file which they may have uploaded, may not have uploaded. We are getting these all on 24th of December, my lord. We did not get there before that. So that file has been created on 23rd. This has been created on 8th of November. Then, my lord, will kindly come to page 368. All the so-called relied upon documents. 368, my lord.
Yes.
Again the same, my lord, 8th of November created. Your lordship will find. Then, my lord, the last file, which is RUD 3, this is also 8th of November. Prima facie anomaly, my lord. Which files are being given to us? Not first thing, they are not in form of paper books, as per the regulation. Now, my lord, your lordship knows, my lord, since that Selvi Jalalita case, that whatever is in law has to be done, whatever has been prescribed in law, it cannot be done in any other manner. My lord, I have relied upon those judgments, I will come later. Now, my lord, kindly comes to page 370. This is what we have been given as RUDs.
Yes.
Your lordship will find Panchnama by the line, my lord. Panchnamas have been done, search and seizure Panchnamas. Then, my lord, kindly turns over seizure memos and Panchnamas.
So these are the list of documents.
These are the list of documents which they are saying that they have relied upon.
Correct.
Right, my lord? Now, my lord, we come to, I take your lordship to my letter dated, my lord, 4th, I believe, my lord, kindly gives me a minute. Lordship will kindly come to volume 3 itself. My lord, annexure P15. Kindly sees, my lord, whether the page is 300 and page 311, my lord.
Yes.
The lordship will find this is an email and a letter dated 4th of January, my lord. There we sought 2 things. First, we sought extension of time because RUTs had not been provided. My lord will remember we got those soft copies on 24th of December. 5th of January, they had fixed the timeline for giving reply. So we go out and say that please give us the RUTs because actual RUTs have not been given except Panchnamas and seizure list. Whatever you have said in your petition, they have relied upon huge number of documents, which we have made a list of and submitted. That see, these are the documents which we have relied
That's
upon.
why I'm asking, where is your request for supply of the document?
My lord, kindly comes to this letter, man. Legal notice as well, with a prayer to extension of time to file reply to the notice of show cause and supply of documents relied upon.
So that you are sending on 4th of January.
4th of January, my lord.
Why you are sending on 4th of January?
My lord, 5th of January, the timeline for giving reply was running out. So after 24th, we have given multiple letters saying that give us the documents. Those are all there.
Because you have received the notice on 18 December.
8 December, no, my lord, that was without the RUD. And we replied to it on 16th of December.
Correct.
On 7th. After that, nothing came. 19th of December, the ED was directed to give the documents.
Correct.
Did not come.
Correct.
24th of December, your lordship, we got those PDF files.
This PDF file when you got?
24th of December, my lord.
Where is the mail?
My lord, that came in a USB drive. But that is under specific
USB drive. USB drive might be some communication.
My lord, no communication.
So how you receive the USB drive?
My lord, that USB drive came by messenger. There is no provision, your lordship. It came by a messenger. That latest copy will be there with the adjudicating authority because they made us sign on it and they took away the copy. They did not even provide us with a copy. It came through an USB drive. All of us, all the 5 petitioners have got on USB drive, which is in violation of regulation 13. I'm not even going into the timelines. No paper book. My lord, will kindly seize in that within the petition itself, when we have made that list of dates, specific pleading is there, my lord. Kindly comes to page 10 of my writ petition, volume 1.
No, what you P15? What is the page P15?
My lord, P15 we asked again for the documents and extension of time. Now, my lord, when they give us
that's why I'm asking. Yes. You are asking for the extension of time. You have received the letter on 8th of December.
Yes.
Correct. Page 58.
Without the RUDs, my lord.
Without the RUD. Yes. Then you have submitted the request on 16th of December.
Right.
Correct.
They should have given by 19th, my lord.
They have not given
they
that.
Did not.
Then you have received the
this USB drive.
USB drive.
24th of December.
When?
24th of December, my lord. Kindly take specific pleading on page 10, my lord. We have given within the writ petition. We have given the date. On 24th of December.
How you received?
My lord, by hand of a person came with a letter saying you sign on it and here is the pen drive. Where he came from, no IDs were shown.
So you have received that?
We have received that.
Without any of...
No, we fixed our signature on that particular letter which that person had brought.
On when you received 24th December?
24th of December. On 24th December, my lord, we have received.
Then?
Now, 4th, we asked for extension of time.
Yes.
And that we have not received documents, please extend. They did, my lord, kindly now takes up from page 311 onwards. The sequence will be clear. So 4th of December, we send them a request that, and we give detailed grounds. My lord, kindly seize my letter, which starts at page 311. Sir.
Yes. Then?
My lord, this is a detailed representation your lordship will find. 311(2). If your lordship wants, my lord, I can take your lordship through the representation.
Yeah, then?
Then, my lord, your lordship will, for once, my lord, kindly seize at page 316. I'm just showing part of it. I'm not even taking your lordship through the details. Kindly seize.
Yes.
Your lordship on top. In addition to the and without prejudice, it is stated relied upon documents cannot be limited to documents marked as RUT by the ED supplied to the respondent, though not acceptable legally as not being part of a paper book, as well as due to the issue that they could never have found part of the document signed on 13/11/2025 when the said RUTs were ostensibly part of an application being OA number so and so filed on 8/11, but should be interpreted to include all documents referred to and stated in OA number so and so. Whatever they have relied upon, that all documents they are stated in OA number, my lord, that has to be supplied to us as relied upon documents. Whatever they are just coming and saying that, oh, this is relied upon documents, marking it with it by the nomenclature, doesn't make it to the relied upon document.
Yes. Then?
Now, my lord, the detailed reasons we have given. Now, what happens is to this detailed representation, your lordship kindly comes to page 320, P16. This is the reply. 5th of January, my lord.
Yes.
My lord, the learned adjudicating authority, page 320.
Yes.
At page 320, my lord, annexure P16, it says, I am directed to inform you that having considered your submissions, in view of the statutory time limitation under section 5.1, now we again protested, we are under section 8.1, we are not under 5.1. Your request for extension to file reply is allowed. Hereby allowed to file reply for respondent number so and so to so and so till 25th of January. Now, my lord, what we have done after that? Whether we have a stand before your lordship to say so. Now, my lord, kindly sees that thereafter kindly comes to page number 321.
Yes.
Now, my lord, the ED had been directed, my lord, will remember, on 1912 to supply documents. Till now, no compliance has happened. Now, my lord, kindly comes and sees at page annexure P17, my lord, before sees the top, which is a reply by the learned adjudicating authority on 23rd of January, kindly sees what we have said on 23rd of January, because our time is running out on 25th of January. We say, my lord, demand of justice for supplied of relied upon documents by the ED and further extension of time to reply to the show cause notice dated so and so. Now, my lord, kindly turns over, and I am not taking your lordship to the subjective part, kindly comes to page 323.
Yes.
My lord, we have given certain precedents of Jaisekar of the Delhi High Court. Your lordship is probably will be aware of, my lord, where that all relied upon documents to be provided to us is already, the precedent is there. Now, my lord, from page 323, your lordship will find.
So this page 321.
321.
Who has sent this mail? To whom?
The first mail we have sent, my lord. That is at bottom on Friday, 23rd January, 8:45. Your lordship will find this is our mail.
Yes.
Saying that please supply us, because 25th the date is running out.
Yes.
Now, my lord, they give a reply on the same day at 4:50 p.m. directing the ED, saying for your necessary comments to be sent by 24/1/2026 to the adjudicating authority.
Yes.
So the ED had to reply to this representation that we made by 24th to the adjudicating authority. I went for inspection, my lord, I have not found it on record, and when we applied for certified copies, they have also not been given to us. Now, my lord, kindly comes to page 323. What did we say? In substance, my lord, what did we say? My lord, kindly sees at the bottom the table starts. Table starts, my lord. We have gone paragraph wise in the OA, saying that in this paragraph you have relied upon this document, kindly give us a copy. On this paragraph you have relied upon this document, give us a copy. Absolutely paragraph wise of the original application, even though that is, we don't know, my lord, when it has been signed or uploaded or whatever.
Yes.
The whole chart, your lordship, that runs to multiple pages, and it covers each of the document PDF documents separately. RUD1, RUD2, your lordship will find in sequence. This ends at, my lord, this ends at page 335. Now, my lord, kindly comes to page 336. That same, my lord, this is a repetition of that particular reply from the authority.
Yes.
On January 23rd, for your necessary comments. They had to give reply by 24th. Now, my lord, your lordship may kindly remember, my lord, my time is running out on 25th. Now, my lord, kindly turns over on in paragraph annexure P18.
Page
337.
Yes.
Now, my lord, this we sent on 25th. We say, my lord, that legal notice for withdrawal or rescission of the show cause, notice dated so and so under section 8.1. This is the notice we serve on them, saying that, see, till date, whatever RUDs are there, you have not provided us anything, not the ED nor you, neither the ED nor you.
Yes.
And this again, your lordship, it's a very detailed representation, not in a one line, my lord. Your lordship will see with annexures of our previous letters, and then, my lord, kindly comes to page 343. Your lordship has come, my lord?
Yes.
Your lordship will find the parawise comments.
Yes.
Why we are saying runs, my lord, runs through the whole way, and everything has been covered. This is on 25th. They don't reply. Neither they extend the time nor give us any reply. Now, your lordship will kindly come to, my lord, annexure P19 at page 372.
Yes. Yes.
We inform the learned adjudicating authority that we have given 50,000 pages of documents for each of the respondents, and this is the Google Drive link which has been shared with the ED. We are sharing with you also. The Lordship will find that email, my lord, at page 372.
Yes.
Yes, my lord will kindly see the body of the email. Under instruction so and so, my lord, I am submitting the Google Drive links which contain the documents received from ED and all documents submitted to ED applicant in so and so with a list of dates and index of documents. So total thing, whatever we have got and whatever they have not given, and whatever we have given to them, which for each particular petitioner, my lord, runs to 50,000 pages, have been shared with both the ED as well as the AA. No reply comes, and they don't give us the documents.
So why you have shared?
My lord, we have shared because this has to be in front of the learned adjudicating authority in the event, my lord. I will show you the rule, my lord. In the event, we still get that particular RUDs, whatever we have asked for, before the date of hearing. Now, my lord will kindly take up the rule. Kindly comes to, my lord, the procedures, kindly comes to, my lord, page 141 of that Bear Act.
Yes.
Regulation 13, my lord. Your lordship will find, kindly comes to, my lord, regulation 15 at page 143. What is the regulation? Page 143, my lord.
Yes.
My lord will say filing of reply to the notice. The reply shall be filed by the defendants on or before the date fixed for hearing.
Correct.
So I have the maximum possible time till the date fixed for hearing, which is, my lord, 9th of March, which has been fixed. So even before that, if they provide us, then also this will become material issues. Therefore, we shared with the learned adjudicating authority because the ED never shared these documents with them.
Yes.
My lord, we took as far as possible the due diligence possible, my lord. We have done it from our side.
So your submission is that without receiving the document, you have given the reply to the adjudicating.
I cannot give, my lord. I am not in a position to give.
So what is this? That's why I'm asking. What is the 372? This is a legal notice.
My lord, legal notice. This is not a legal notice for withdrawal or rescission, my lord.
So
that has to be adjudicated.
Correct. So 372 is a legal notice to the adjudicating authority.
Before that, my lord, we have given on.
You are not giving a reply to the adjudicating authority.
That we are not in a position.
Subject to receive of the document, you are submitting this reply. Where is that?
We are saying that we cannot submit a reply. I will show your lordship the precedent. What
you could have been submitted the reply, interim reply, keeping the
with utmost humbleness, my lord, and subject to correction by your lordship, I will show the precedents that gives us the right to receive all relied upon documents. And if they are not even ready to give us the documents, it may happen that they will say that this part of the document cannot be shared, that cannot be shared, my lord. There is a precedent saying that that has to be redacted. But they cannot deny us at the stage of section 8.1 supplying of the documents which they have relied upon, on which basis, my lord, the learned adjudicating authority has issued us the show cause, because, my lord, the issue is we have been stamped with the stigma that prima facie we have been found to be laundering money. That is the prima facie finding. And that is a very damaging finding, my lord, for business groups and people who have been doing genuine business for 40 years and all. Just because I may have some interaction with somebody in a PMLA case, because we are not there in the predicate offense.
Nowadays, nobody is clean.
My lord, as your lordship has fallen from your lordship. Well, I am not. Now, key. That is all we are asking. Now, my lord, kindly.
So that's why I'm asking the page 372.
Yes.
372, how you can
give. 372 is only giving the links, my lord. This is in continuation of our notice of 25th of January. My lord, kindly sees. In which we have given that.
So what is the prayer in this 372? What you are asking? Out to
372, we have not asked for anything from them. We have only provided them the Google Drive link. What we have asked from them is at page 337, my lord, annexure P18. This is January 25.
Then what has happened?
This is what is our legal notice which went to them.
Correct.
Saying that, see, these are the documents which should have been supplied to us, and these have not been supplied to us. And the basic principle, my lord, we have relied upon is that the learned adjudicating authority does not have to follow the rigors of the CPC. My lord, that is there in the Act itself. But it is not out of or bereft of the provisions of the Evidence Act. Now, whatever is maybe the opinion of somebody, that cannot be a relied upon document. I can think anything under the sky about something, and you put that on in front of me and say that you give a reply to the opinion of somebody, my lord. Kindly appreciate the condition that we have been put in. Not only that, whatever has been seized. Now, my lord, kindly seize where are my rights? Where are my rights, my lord, to get this? 372 is that Google Drive link your lordship will find. Then your lordship will find, my lord, we went for an inspection. Your lordship, our inspection was granted on 10th of February. We went for an inspection.
Page?
That was given on 10th of February, my lord. Kindly comes to page annexure P21 at page 395.
Yes.
Now, my lord, we'll see the time has been given 10/10/2026, 12 p.m. to 3 p.m.
Yes. Director informed me that you are allowed to inspect the document.
Yes. Now, my lord, we'll see that we have given the charges and we have inspected. Now, your lordship will kindly come to page 399. Onwards, your lordship.
Yes.
My lord, our application for certified copies in Form 12, which is under the regulations. Now, your lordship will find that what we have asked for, copy of case preview format, which shows which date the documents were uploaded, because that confusion was there, 8/11, 13/11, we don't know. Second, your lordship will find reply by defendant number 1, so and so, there was a reply by one of the defendants. Then section 8, show cause notice with copies and RUDs, reply by defendant number 3 and 15, and copy of Form 12 we have also given. Now, my lord, 5 pages and with documents. These have not been till date provided. Then your lordship will find.
Sir, you have inspected the document in terms of the notice.
Not only
as
the
per the
notice,
page 90.
the OA which has been given to us.
Correct. Page 395, the notice of inspection and inspected that.
Inspected.
So what remains further?
No, these are not there on record, my lord.
What?
That's whatever we are asking, whatever is there in the OA, whatever they have relied upon, are not there on the record.
Where you written that?
My lord, kindly cease.
Where you inform the authority that after the inspection it is the documents not available?
Which one?
Where is that? You were inspected. After the inspection, you are telling that the documents are not available. Where is the representation given to the authority that during inspection you did not find any document which you are?
We have not. It's not that we have not found any documents. We have found the OA. But whatever we have asked for is relied upon documents. What is
correct? That's interesting because they may take a plea that the already inspection has been carried out. If the inspection has been carried out, now you are telling that the inspection, the relied upon document has not been shown to you. So where is the representation submitted by you?
I have a right, my lord, to get the copies, to give a reply. Inspection I carried out, my lord, I will show your lordship the regulation. Inspection I have carried out to see what is there on record, what was actually considered by the adjudicating authority while issuing that show cause notice. That was the only sole purpose of my inspection. My lord, that doesn't bar me from getting the copies of the RUTs. Number one, my lord. My lord, kindly sees. Thereafter, my lord, we have given them a. Now, my lord, before that, my lord, they inform us on 20th of February that 9th of March has been fixed, which is at page 405. Thereafter, the learned advocate in Delhi, he submitted a representation, my lord, kindly comes at page 408. I respectfully submit, I have already inspected the case file. My lord, page 408, annexure P25.
Yes.
Through this email, I request that copies of the rejoinders filed by the Enforcement Directorate to the replies, my lord, because the direction was given on 24th. Filed by the respondents in the above mentioned matter be kindly provided. Further submitted that the matter is listed for final arguments and requested documents are urgently required for the purpose of effective representation. Nothing comes on this, even today. So we did not get the copies of the documents. Neither we get the certified copies applied for. And the date has been fixed on 9th of March. Now, my lord,
when the inspection was done?
My lord, the inspection was done on 10th of February, my lord.
10th of February.
Yes.
And you are writing a letter on 23rd of February.
Yes, after they gave us the date, my lord, on 20th of February. That
why? Immediately when you inspected, why you not given the letter to that? Yes, we have inspected the document.
Well, that they have taken from us on the case file. I went for inspection myself. They made us write on the case file that I have already inspected. So there was nothing that I would have to inform them. I went in person.
Not informed regarding inspection. My question is that your specific case, after the notice of inspection, you inspected the document. Once you inspected the document, now you are taking the plea that at the time of inspection you could not find the RUD document.
I'm not taking that plea, my lord. That is not my prayer in the writ petition. This is my submission that I did not get because I went myself.
Correct. So you are telling that you are not, that relied upon document was not available. You have signed in the document you inspected.
Now there is a confusion in this. The relied upon documents which they are saying relied upon documents, those are there in the record. Whatever we have asked for in our multiple
Correct. What you are asked for, that was not there.
That was not there.
So that's why I'm asking. That's why I'm asking. You have inspected the file on 10th of February.
Yes.
And till 23rd of February.
20th they informed. Kindly see at page 405. Kindly comes to page 405. This is the intimation for the final hearing date. Within 3 days, we went and told them, sir, till now we have not got documents. Please provide us. So after this, my lord, we came and filed the writ petitions.
Okay.
Now, my lord, kindly, for once, my lord, kindly sees what are my rights, what are my entitlements. Whether I can have this or whether I cannot have this.
Yes.
My lord, for that, my lord, I will take your lordship. My lord kindly takes up that particular procedural rules. My lord comes at page 143, regulation 1718, fees for copying and inspection of records.
Correct.
Now, my lord kindly comes to regulation 29. 29, my lord, at page
certified copy.
Application for certified copies.
Yes.
Now, my lord kindly comes to that form 12. What have they said, my lord? Now, this is I am submitting on my as another officer of the court, my lord, my learned colleague from Delhi said that they are saying that all records cannot be supplied verbally. They are not giving any reply on record. Now, my lord, without this, I don't have any other option to submit this because this has come from another learned advocate who is an officer of the court. My lord, application for copy of record. Now, my lord, the question comes that what are documents and what are records under the Act? My lord, kindly comes to section 21W. That is at my lord page.
Records,
my lord, 21W.
Yes.
Include the records maintained in the form of books or stored in a computer or such other form as may be prescribed.
Yes.
Now, my lord, kindly comes to what I can get. My lord, this is an application for getting certain particular reliefs under section 20 and 21 of the PMLA subsequent to 17.4. Now, my lord, kindly comes to section 21. That section 21, my lord.
Yes.
Retention of records, kindly see section 21.2, my lord. The person from whom records seized or frozen shall be entitled to obtain copies of the records.
Correct.
Now, my lord, my digital records have been seized. My money has been seized. Therefore, I cannot ask for the copy of the money. I am not asking for that. But my digital records have been seized for other petitioners. Nothing has till date been provided. Nothing has been provided.
So now in this writ application, what you have prayed
my lord,
for?
we are only praying. My lord will kindly take up my prayers, my lord, because I will not go just like that. My lord, what have we have prayed? Want to go to the page. My lord kindly comes to my prayers.
Yes. Kindly come to the B.
Kindly comes to my lord B.
Yes. Relied upon documents. So they are telling the relied upon documents, what is available in the file, that is the relied upon document.
They are not saying anything. They are absolutely silent. There is not one part. There are multiple directions upon the ED to give response to our queries. On 19/12, they were to give us copies. They did not. 24/12, we got on USB drive, which is in violation of regulation 13 of the procedural rules. Till date, we don't have the paper books.
Yes.
Now, my lord, will see that on 24/1, they were to give a reply to our askance of that relied upon documents, the chart. Nothing has come till date.
Yes.
Nothing has come. But we are very specific, my lord. We are not asking for any extraordinary relief.
That's why I'm asking. You are going here and there. This has been seized. Total 1 hour you have wasted. You are calling. Your only question is that the so-called notice. Since beginning, I am asking, what is your prayer? What is your prayer? You have wasted 1 hour time going that code, this code, this code. Your only question is that the so-called notice which you relied upon the document not solved. One line, and every day this court is doing that matter.
My lord, I will.
And that's why I fail to understand. Either you have not understand this code, or this code is not understand you.
Lord, I absolutely beg your lordship's pardon, my lord.
Every day 1 or 2 matter like this is coming before this court, and this court is passing regularly the orders.
My lord, I beg down to your lordship.
And what is your prayer be? This is only for the 5 minutes for this court.
My lord, I only tried to show your lordship that how the whole process has been vitiated.
That I have dealt with.
My lord, that.
Yes. Why the document is not been served?
I am grateful.
Lordship, first of all,
Please see the court's position. Shortcut the matter. If you know that the judge is not understanding, then you can proceed with that matter.
I tender my unconditional apology, my lord.
The court is asking time and again, what is your prayer? What is your prayer? You are putting on all the pages. I have taken note of 1 page, but the prayer is only this. I don't know.
My lord, I only tried to. I am just begging your lordship.
If this court will give the 1 hour time to one matter, nothing. All the advocates will go without any work.
There were 5 matters analogous, your lordship. I just tried to take your lordship to the facts, my lord.
Yes. Yes, sir.
Yes, my lord. My lord, over here, kindly consider section 8, subsection 2.
Yes.
My lord, the statutory mandate has given the authority concerned the enough power and protecting all the litigants.
Correct.
The adjudicating authority shall, after considering the reply, if any, to the notice under so and so, hearing the aggrieved party and the director or any other authorized by him in this behalf, take into account all relevant materials placed on record before him by an order so and so, issued so and so. Well, it encompasses all the principles of natural justice and alleged aggrieved. Because, my lord, kindly come thereafter to the page 133. This is our application at 132. Kindly see thereafter. RUD 1.
Section?
Lordship. Malad, Annexure P11.
Annexure P11. No, page 133.
Page 138. 133 or 138. Malad, there are 2 page numbers. The scan copy is 133 and the physical copy is 138.
Yes.
Malad, kindly see the RUDs which are given as a part of our original complaint before the
133 is the FIR. Enforcement
thereafter, Malad, before that.
Material relating to commission of offense.
Malad, before that, on the left.
Prayer.
Yes,
132 is the
thereafter. Then the following page. After the prayer, the following page. Lordship will kindly see RUD 1. Right. 138.
138.
Annexure P11.
P11, page 133.
133.
Yes.
Well, this is an RUD. My learned friend has been.
This is information.
Well, so many pages, Malad. It is coming from here. I am marking it. Job tab at page time. Malad. Don't mind. It's page 158. No, George Sabet page the main channel. Well, towards the top, your lordship will kindly see 138. Sorry, kindly see RUT 1.
Yes, yes. Yeah, there.
Yes. Kindly turns to the other pages, my lord. The Panchnama, that is the following after 3 pages. My lord, lordship's pages, my lord. Lordship's
133.
133. My lord, then come to
133 is RUD 1.
Yes, my lord. 136. 136.
136 Panchanama.
Yes, my lord. Kindly see,
2A.
these are our RUD. I am not going into the merits of the document.
2A.
2A. Thereafter, 139, schedule of seized records.
Yes.
It is going till 158. The necessary certification and everything till 158. Well, in the second volume, it is running to that.
Yes. 158 or 157?
158.
158 is the Panchanama and Cum Caesar.
Caesar memo.
Yes.
Thereafter, Malad, your lordship will kindly see the first is the section that what is the power of the adjudicating authority. Then my learned friend has then there will be an order. Kindly come to section 26. Section 26, agreed by any order, save and otherwise provided in subsection C, director so and so by agreed by any order passed by the adjudicating authority may prefer an appeal to the appellate authority,
Yes.
appellate tribunal.
Yes.
Thereafter, my lord, let us see the Deepak. Thereafter, your lordship will kindly see the regulation rules that is of 2013.
Yes.
Kindly come to regulation 13, sub-regulation 11. Notwithstanding anything, the electronic mode of service is recognized by the said regulation. But before regulation 14, sub-regulation, before regulation 14, 11. Notwithstanding anything.
Rules.
142 probably. 142 of your of the book. Of the book,
Yes. Section rules.
It is regulation 13,
11.
Regulation 11, man.
Notwithstanding anything. Electronics mode. Yes.
Yes, Mal.
Yes.
Therefore, thereafter, regulation 15, reply has to be filed. Malad, whatever Malad, over here, there are 2 compasses. One is the criminal liability under the PMLA, and one is the civil consequences suffered. Malad, over here, the adjudicating authority is parameteria to a civil court because all the provisions of the CPC, Malad, in the regulation, Malad, over here, Malad, just a minute, Malad. The provisions of the Lordship will kindly see regulation 21. Regulation 21.
Examination of witness.
Yes, my lord, and issuance of commission relating to the issuance of commission for examination of witness and documents. Therefore, if any documents are to be produced, the law has given the ample power to the adjudicating authority to undertake such exercise. But over here, my lord, he is playing around the boundary line and trying to, over in some pages, he is admitting that I am getting the documents, but it is not to my satisfaction. But this satisfaction can never be accompanied, cannot be fulfilled if he does not adhere to the principles that he must file a reply according to the documents available to them. In his writ petition, he is saying that my document submitted to the ED during investigation is not being relied upon. It is his document to prove that these are not part of the proceeds of crime.
Yes.
when a natural justice is being provided, my lord, he is now rebouting the entire issue and coming before this court when the adjudicating authority has the ample power to undertake such exercise and protect the interest of the petitioner.
Okay.
My lord, my understanding.
No, let him continue because that will break the tempo.
Yes. Therefore, in my respectful submission, this is premature. He has to appear before the adjudicating authority, and if there is any order, he has an efficacious alternative remedy. He cannot delay the entire process of adjudication and frustrate the time limit which is prescribed under the statute, that is 1 month is remaining for conclusion of the same. Therefore, I am praying for dismissal of the.
Yes. My lord, I am now going to place, my lord. First thing, your lordship will kindly take up that same regulation what my learned senior friend has referred to. What is allowed to be electronically served. Notwithstanding anything in subregulation 3, someone on notice may be communicated through electronic mode as provided in section 13 of the IT Act, and transmission of such communications shall be regarded as a valid service. So I can get a summon, my lord, I can get a notice. My lord, kindly turns back to issue of summon and notice, regulation 13(2). Relied upon documents are not to be served. They are specifically to be provided as a.
My lord, he did not come at that point of time.
He is no, my lord.
No, my lord, he cannot. My lord, I'm just saying that he did not come at that point of time.
I did not interrupt you.
The question of
immediately raised the issue.
Soft copies have been provided.
We have immediately raised the issue.
And hard copies are there.
That whatever documents you have given, because first they are saying that application filed on 8/11. We are getting a document signed on 13/11. When it has been filed, when it has been uploaded, we don't know, my lord. That is why, my lord, I had to take your lordship in detail. That how the whole process has been vitiated by perversity and arbitrariness. Whatever actions they have taken, or whatever actions they have done to come to this juncture are not as per law. They had to give us bound paper books.
Yes.
Now, my lord, will kindly see what I am giving your lordship is. This is a judgment, my lord, reported in 2018.
In reply, my lord, lordship will kindly.
Reply. My lord, I had not completed my submissions because I told your lordship, my lord, I want to rely upon certain proceedings.
Okay, come to Monday.
Monday.
My original side.
This is why I didn't interim stay, your lordship. My lord, otherwise I will not be represented there, no?
No.
My lord, this is fixed on Monday, your lordship.
Yes, I will take on Monday.
My lord, this hearing is at 2:30 on Monday.
What can be done?
My lord, we have been trying since last week, your lordship knows.
So what can be done? I have given the time, but you have taken so much time. You know that the court is having restrictions.
Protects us till Monday, your lordship. We are not asking for an elongated period of time. My lord, kindly protects us till Monday. My lord, this is absolute injustice what is being done with us. Because your lordship kindly then, my lord, kindly allows me 5 minutes. Now, kindly seize this precedent. One precedent I will.
So why you not given the earlier before arguing the matter by the respondent?
In the middle, my senior friend.
Not senior. You have stopped.
My lord, I was going to place the precedents, your lordship. My lord, this is.
See, this type of the argument this court never appreciates.
My lord, kindly allows me. I am begging your lordship.
2 minutes. 2 minutes argument. You have taken the 2 hours.
All my incompetency as an advocate, your lordship, should not be visited.
I am not doubting about your competency. But you see, the competency of the other advocates should get the chance before this court.
My lord, your lordship has seen what perversity has happened. My lord, kindly allows me to place the precedent.
When you mentioned it, was stated that Mr. Dilapati has stated that 2 minutes matter. That's why I kept. Otherwise, I could not have.
My lord, that is my fault, your lordship. That is.
That's why your fault.
That, my lord,
you suppressed the fact before the court and matter get the listed today. So why you stated that it is only a 2 minutes matter?
Well, this is only regarding that one prayer, your lordship.
Okay, 2 minutes. I will hear on.
But I only took your lordship to the facts because otherwise the perversity could not have been stated, your lordship. Kindly don't get angry with me.
Not, I am not angry with. I am worrying about the other matters.
I agree, your lordship, but your lordship kindly.
Once you are taking the bar resolution not to sit the court at 3:30, and next you are arguing the matter so that other advocates could not get an opportunity.
I am here only. I am not. I accept your lordship. I am very sorry, your lordship. Kindly.
Where the original matter will be taken up? When the original matter come on Monday.
Kindly protects us till Monday, my lord.
No.
My lord, I beg you.
Unless without hearing how the matter can
be. Then kindly keeps it at to be mentioned, my lord. I will finish within.
Why to be mentioned? You come sit here, dictate the order.
I am praying because it is fixed at 2:30, your lordship. If your lordship decides, my lord, then I can just take the consequential action.
You take all the plea before the other adjudicating authority.
My lord, kindly passes one line order that this is fixed on Monday, my lord, at Swansea. My lord, otherwise I won't get any relief there, your lordship, without the stay. My lord, kindly.
Last moment you are coming before the court
My lord, we have been trying since
and
last,
putting pressure upon the court to hear the matter here itself.
we have been trying since, my lord, we are sorry, your lordship, but we have been trying since last week, my lord. But your lordship knows, my lord, what was my
No, the 19th hour the court will be in Haribari and will pass the stay order.
Your lordship will see the filing date. My lord,
Counsel for the petition argued the matter at length. Counsel for the respondents also argued the matter. Counsel for the petition intend to give reply to the argument made by the land counsel for the respondent. Due to paucity of time, hearing could not be completed. Let the matter appear on Monday as first matter. But I will give only 10 minutes.
My lord, I am grateful, your lordship.
If your lordship takes up the original side matters, your lordship will remember.
Not yet shifted.
I'm sorry, my lord, but I'm not saying, my lord, the matter to be taken up today, but my lord, on Monday, my lord, let it come at the top of the list, my lord.
This is not the time for mentioning.
I had mentioned in the morning, your lordship.
Mention, I have refused.
No, my lord, your lordship said, let us see, my lord.
Okay.
I can reach 47. So kindly, my lord, considers this.
I have already reached 30. Then 47 is within 15 matter.
My lord, 10th is the tender last submission date, my lord. My entire.
Sorry, sir. Yes, call the list.
My unconditional apologies, my lord.
Please appreciate the court's position and you argue the matter.
Please, kindly don't take me up.
So many seniors are argued, they know.
My lord, kindly don't take.
But taking this type of the time, wasting of the court's time, then it is very difficult.
My lord, I am unconditionally begging up.
Okay, no problem. Yes.
My lord, I am coming this to me Monday, my lord. Clearly at the top, my lord. Only, my lord.
I am obliged, your lordship.
Milord, before ordinance I mentioned, Milord, may I take your leave, Milord? My item number 51 was listed today, Milord.
Item number 51 now?
Appellate side, Milord.
Record an order, appellate side, item number 51. Record an order after item number 51. Though the matter is listed as item number 51, but due to paucity of time, matter could not be taken up for hearing. In the mid of hearing of the original side cases, learned advocate has mentioned the matter. The attitude, full stop. This type of the practice could not, this court is not allowing this type of the practice. Let the matter go out of the list.
Milord, I am from Delhi, Milord.
Let the matter go out of the list.
Milord, I apologize, Milord.
Next, call the matter.
Milord, may I have your lordship's leave, Milord? Tuesday at 11 p.m., Port Trust will evict me. Milord, leave to short serve.
Take on rent.
I'm sorry, Milord.
Take on the rental premise.
Take on?
Take on rental premise.
No, this is rental. This is rental. But the sword is hanging on my neck. I'll take a try on Monday. But strangely, Milord, I don't want to run away without paying rent in any way. And I have not defaulted.
What is the notice?
Milord, the notice is here, Milord.
The original side?
Yes. 11 p.m. But it's 11 p.m., but I think it will be a.m. 11 p.m. they won't throw me out. 11 a.m. I think they will. On the first page, Milord, is the time at 11. What we want is, Milord, our lease has expired.
You're not paid the 3 crore rupees.
That's what they say, but I have paid as per all their bills. I have to get back 2 crores of extra payment over schedule of rates, and the land use policy says that when lease comes to an end, you have to put it on retender and I must be allowed to participate. So that's what I want.
See, when matter can be taken?
Monday, not before that.
No, Monday also see.
Original side. I'll take a chance.
Original side, then after lunch only. At 3 p.m.
After 3, Milord.
3 already fixed.
3:30
also fixed.
4, I'll take a chance.
3:30 also fixed. Then
4, I'll take it. 5 minutes.
Better 10 and 11th, you will work. I got the information there is a resolution.
Well, I am always here. I was, I'm a known violator.
9. 9
2 PM to 2 PM to 4 PM.
With your lordship's permission, may I kindly mention item 13, my lord's original side matter, my lords. Lord, this matter was kept as item 13 for today, my lord.
Item 13?
Cut, yes, my lords. Terai versus Pamela Sadalagundam.
Yes.
I have a humble request that it may be taken. It's not going to take more than 5 minutes.
Let me see other matter first. Yes.
Well, only extension, my lord, I'm wanting, my lord. My lord, sorry, my lord. The last date, my lord, is on 9th, my lord. So, my lord, we are seeking an extension. The matter was fixed as item number 84. It is now ready for hearing.
Item number?
Yesterday it was item number 84. So we mentioned, my lord, for extension of interim order. Your lordship extends it and fixes any day, my lord. Because there is a, my lord, what happened, my lord, here, my lord, an appeal was preferred by us from a PP Act order, my lord. Appeal court sets aside the entire order, one of the few ones. After that, my lord, they are still issuing me notices.
Under PP Act?
Under the same PP Act. So when we got an interim order, there was an order from your lordships to give.
So what remains here?
But because they, and final order, obviously, my lord, and my lord, I have also paid them 25 crores in excess. I want a refund of that. They are not giving.
What is the prayer here?
Both. One is not to issue such notices. And second is, my lord, I should get back the money because, my lord, they are not entitled to keep it after the appellate authority order, my lord.
Who is for the other side?
My lord, I appear, my lord, on the last occasion, my lord, the coordinate bench of this honorable court had passed a direction indicating us to file an affidavit indicating how much we have claimed and how much we say is still payable. My lord, they have filed a reply only to that calculation to that effect. If my lord may hear out the matter, we have a point of maintainability which has been kept open, my lord. Lordship will keep all those points open and my lord hear the matter.
Your lordship wants to hear it out.
It's calculation, my lord. They say they have to get money. We say we have to get money.
It's not only
Calculation. Is to be mentioned for extension of interim order. Counsel for the petition submitted the interim order is till 9th of March 2026 and paid for extension of interim order. Counsel for the respondent submit that the pleadings is completed.
Yes, we have not filed any affidavit in opposition to the writ petition, my lord. We have filed an affidavit in terms of the court's order disclosing how much we say is payable to us.
So you will not file affidavit?
There was no direction given because we wanted to argue the maintainability point.
If you want affidavit, then I will. You will rely upon the report. Then I will go record that.
My lord, we have not filed an affidavit in opposition. But if your lordship keeps the maintainability point open, with us filing
By which order the maintainability was kept open?
My lord,
the first order, your lordship, my lord, that was the order dated, my lord, 14th of August 2025.
14th August.
My lord.
Where is?
My lord, will kindly see page 3.
Respondent is kept to be decided at the time. Maintainability raised by the respondent we kept here.
All the maintainability ki chilo?
That though the respondents have not filed the affidavit, in opposition, but have filed the calculation.
That was the direction in terms of that honorable
court. The order passed by this court. In view of the above, full list of the counsel for the respondent also submitted by an order dated 14th August 2025. This court has kept the maintainability point open. In view of the above, the interim order passed by this court is extended till. क्या भाई कोई डेट है क्या hearing का?
My lord, in the event, my lord, your lordship, my lord, after hearing the maintainability point, my lord feels otherwise we may be granted at that.
This court is having a direct nexus. If you want to argue the matter on merit, you argue the matter on merit. If you want to, because I will not take point by point, maintainability, merit, law point. This court will take all the points, you know. Then this court will dispose of the matter. Now, if you want to argue the matter only on the point of maintainability, I will decide the whole written.
All documents then your lordship will give some time to us, my lord. In the event we file an opposition to the main writ petition, my lord, we'll file it in the meantime.
Look at it then.
Keeping the maintainability.
Counsel for the respondents press for time to file affidavit in opposition. Let affidavit in opposition file within 3 weeks. Reply within a week thereafter. The matter give the 4 हफ्ता के बाद. आज कितने 7th April है?
Very grateful.
3:45. 7th April at 3:45 PM. as a specifics matter.
Very good.
Interim order is extended till 10th of April 2026 or until further order, whichever is on.
My lord will kindly record this is without prejudice to our arguments with regard to maintenance.
It's kept open.
It's already there. Not required to file because 14th August there is already kept open. Yes, next.
May it please your lordship. Your lordship has been kind enough to grant interim orders from time to time. Lord,
I am for the relay authority, my lord.
The
Lordship, I am for
Lord,
defendant.
the interim order, my lord, is till 10th of March. And there are 3 GAs in your lordship's list. GA number 1 is our interlocutory application,
Yes.
in which there is an interim order which has been continued from time to time. GA number 2 has been disposed of. That was our application for extension of writ of summons. GA number 3 has been filed by defendant number 2. There no affidavit directions have been given.
What is the J2?
J2 has been disposed of. J3 is by the bank. They seek leave to file their written statement beyond 90 days.
Okay.
But there no opposition has been directed.
This is a commercial matter.
Commercial.
Yes, ma'am, commercial.
Your Lordship,
The extension of time after 180 days.
No, Your Lordship, the extension of time for filing WS application is filed, it is affirmed and filed on 17 July effectively, but due to some difficulty in the technical part of the department, it shows that it's filed on 2nd of August.
After 90 days.
After 90, but within 120 days, Your Lordship.
Within 120 days. Where is the written statement?
Written statement is 7 July, Your Lordship.
Filed.
7 July, Your Lordship, it was affirmed, but it was kept with record by leave granted by Your Lordship on 22nd July, Your Lordship.
So, Lord, that application will have to be heard, Lord. Kindly give short directions for filing a formal affidavit. In the main matter, Lord, the interim order is till 10th of March.
GA1.
GA1.
The counsel for the petitioner submitted, plaintiff submitted. The interim order is till 10th of March 2026.
Your lordship order of 15th of January.
Interim order. The counsel for the plaintiff further submitted, the defendant has filed an application being GA3 of 2025, GA-Com 3 of
If it is bank authority, my lord, bank authority.
No.
Bank authority.
GA-Com 3 of 2025, praying for extension of time to file written statement. But there is no order for filing written affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, that we file within a week thereafter. Let the matter appear on 31st of March 2026. Interim order is extended till 2nd of April 2026 or until further order, whichever is served.
3 p.m. Can you fix the time, my lord?
3 p.m. Lord, if it suits
3
the
p.m.
lord.
then it will 3 p.m. khali hai.
3 p.m. better, my lord.
Then 1st April 3 p.m. 3:45 p.m.
My lord.
Great.
April 3
Deeply operated.
Next. वो कल करो वाला
The interim order probably yourself then? Interim order, sir? Lordship has kept the matter on 1st April, interim order 2nd April, not kindly make it 7 more days.
7th April.
7th of April. Very deep.
7th. Deeply operated.
करो 13.
Please.
13:3. Yeah, just because this matter. Yes.
Please, your lordship.
Which for the other side? Yes, Mr. Gupta. Yes.
Lord, the entire payment according to us have been paid. The checks have been cleared, my lords. In terms of the email, my lords, they agreed that if we make the balance payment of 4.5 crores, my lords, they will give a NOC, my lords. We have made the entire payment of 4.5 crores, my lords. It is my humble submission, my lords, that my client has really suffered a lot, my lords. Now, at least when he has paid the money, my lords, he may kindly be forgiven, my lords.
Yes.
My lord, I need not remind your lordship about the matter. Just only thing. This is the interest calculation.
Going by
That's
their-
why I wanted the main original order. Where is the original order? Which date?
But as in the order under contempt, or
Initially, when this order was passed, they are ready to pay the
they were ready to pay.
17/11/23.
17/11/23.
If
No.
if my lords will just permit, it will become easy, my lords. The first order, my lords. My lords, I have given the compilation, the first order itself.
No, not that.
17/11/23, my lords.
No. 16th October. 16th October order.
October 23, my lords.
Yes.
Possibly 17 November records the affidavit filed.
17 November is
17 November order records the affidavit filed by the alleged contempt.
That's the first.
Finally comes to page 3 of the order.
No. First, the 8 crore rupees they have already, no?
Yes, but kindly comes to the second page of the order. 17 November.
Yes.
The second paragraph. The contender number 4. Has your lordship got it, no? 17 November order, second page.
Yeah, contender
has filed an affidavit on his behalf as well as on behalf of the contender numbers 1 and 2, undertaking that the contenders will pay total sum of rupees 8 crore. This is the order. Not being the full and final settlement between the parties, out of which such and such shall be paid on such and such. Then when it kindly comes to the next page. In fact, your lordship may skip and come to page 4 of the order.
Page 4, second last paragraph.
Now the contender undertaking by an affidavit that the contender shall pay 8 crore to the plaintiff, being the full and final settlement, out of which the contender shall pay 1.8 crores, being the first installment on itna, and 1 crore each on 7th installment.
So on or before 30th November 2023.
Succeeding an installment.
And the balance 1 crore for each 6th installment, 7th installment shall be 50 lakhs. Kindly turns over to page 5.
Yes, second paragraph.
Yes, it is found from the record. It is found from the record that in spite of undertaking given by the contenders have not paid payment on the earlier versions, and thus it is made clear that if the contender numbers 1, 2 and 4 fail to pay the above amount as agreed above on any of the month, the amount of rupees 8 crore shall carry interest at the rate of 18% per annum from today till realization of the amount.
Correct. That's what
So,
I want to see.
Yes. So, we are not.
You have received a total amount?
8 crore.
8 crore.
Yes.
So
Now,
8 crore out to have been paid by 30th May 2024.
But that has been paid last week, last to last week.
Last week.
So which is about 2 years of delay. So all that I was seeking humbly is that order mentioned interest
18%.
Yes. So that takes us to 78,94,709. What my learned senior friend is submitting, that there was an email exchange between the parties where we had said that we would receive the amount in full and final, provided you make payment of 4.5 crores, because that amount was lying due and payable for all this time. So on that basis of that, they are saying that please waive the interest.
Now, my lords, only 2 minutes for me. My lords, may kindly have last 4th page, my lords. This compilation only 4 pages from the last, my lords. I'll just read the email, my lords.
Yes.
Lord, first of all, my lords, the last 2 pages are the letter written by them, my lords.
Correct.
In which they acknowledge, my lords, that I have already paid 9 crore 51 lakh 25,000. Second last page, second last line.
Correct.
So admittedly, against 8 crores, I had paid 9 crore 51 lakh odd thousands. Now coming to 1 page before this, my lords. I write an email to them, my lords, on 9th February. Reference to the telecon today, we confirm that we will, my lord, it is their email. I speak to them, my lords. Reference to our telecon today, we confirm that we will issue a no due certificate on receipt of the further payment of 4.5 crores within a period of 4 days in terms of order dated so and so. Back page, my lords. I request them that kindly permit me this period as for no dues for full and final till 18th, on or before 18th. On 18th, I make the payment. My lords, once there is a novation of the contract, section 62-63, my lords, permits me that if you have agreed for a revised amount and I have paid that revised amount, then the original contract need not be performed, my lords. And it is my humble submission, my lord, that my
confirm that we will issue no due certificate in respect of further payment of 4.5 crore within a period of next 4 days.
Yes, my lord.
Correct.
Lord, this 4 days was extended till 18th February, on or before 18th February. Back page, my lords. We are willing to extend the date of receipt of 4.5 crores from you on or before 18th February 26 as per your request.
Correct.
On 18th February, I made good the payment in the court itself, and it was confirmed by them that the checks have been cleared, my lords.
Correct.
It is my humble request, my lord, that my client is actually a victim of circumstances. My lords, once a king, now a pauper, my lords. Despite that, after taking the permission from this honorable court, my lords, I have made good the payment. They told me by a written communication that you make the payment on and so and so we will reduce the interest to so and so. We have made the payment.
No, reduce is not there. Only they will give the no objection.
Yes, my lord.
Where is the question of reduction?
Yes, my lord. I will just
because this is not an agreement. This is an order of the court. Whether the order of the court can be novation.
No, my lords.
By the agreement with the party.
My lords, it is my humble request, my lords. It is my humble request. My lords, may kindly have the last line, my lords, of the email, my lords. The first page email, my lords, bottom of the. I would like to express my sincere thanks to you for your consideration. I respectfully request an extension of time until on or before 18th February, by which date I will make due payment of 4.5 crore as full and final. You agreed that you give it. I am ready to extend that. I made that payment, my lords. My lords, it is not today a question, my lords, whether it is over and above the court. No, my lords, nothing can be over and above the court. What the court says, I have to follow. My lords, but what ultimately, my lords, what is this? My lord, it was just a money matter, my lords. My lords, now that I have paid through my nose all the money, I have sold my property, I have made that payment, my lords. My lords, I beseech to this honorable court, my lords, that some kind-hearted, my lords, approach be taken, my lords.
I really leave it to your lordship, my lord. I really leave it to your lordship. We were going only on the basis of the affidavit which they filed, because we already gave a haircut of 13.5 crores to 8 crores.
My lords,
that we had already given.
My lords, with utmost respect, my lords, I will not question anything, my lords. But that affidavit does not say that I will pay any interest. It was the observation of the court.
No, the affidavit also.
My lords, it does not say. I have read the affidavit. It is on the 3rd page, my lords, starting. My lords, may kindly just have the starting of the paper book, my lords. Just after the affidavit, just after the first order, my lords, is that affidavit. It starts from page 6, my lords. And my lords will kindly have page 10, my lords. Page 10, para 13. Just after the first order, my lords, is the affidavit. Lords, I never wanted to go. My lords, what has been ordered by the court, we cannot obviously go against that. But my lords, may kindly consider my circumstances today. I have been, my lords, my age, my circumstances in life, my lords. My company is shut, my lords. My plants are shut. Lords, page 10, para 13, my lords. That I will make payment so and so, my lords. It was only, it had come through the court, my lords. And we cannot say anything. What has come from the court has come from the court. We are only with humbleness, my lords. We are beseeching the honorable court that please look into my financial position today, my lords.
Yes.
And I have made good, my lords. Once the email was sent, my lords, I have made the payment in that time. Lords, one cannot, backtrack time and again, my lords.
Sir,
I have, my lords, humbleness.
You are appearing in the matter in the last point.
Lords, but
if the court would not be strict, then I don't think
Lords,
your client is so easy to
Lords,
recover.
Only one thing. Lords, only one thing. As and when I came, I assured this honorable court I'll get the money, my lords. I have got the money, my lords. And once they have promised, my lords, that they will take this money as full and final, my lords, I have given it now. Now, my lords, may kindly take a lighter view.
Okay, I am disposing of, Mr.
Please, my lords. Very grateful.
Mr. I am disposing of. Right. It is submitted by the learned counsel for the alleged contemner that the contemner has paid the total agreed amount of ₹8 crore to the petitioners. They further submit that other than the 8 crore, the petitioner, the alleged contemner also paid interest of ₹1 crore 51 lakh 25,000. And as such, he prays for disposal of the content proceedings. Learned counsel appearing for the petition submit that by an order dated 17 November 2023, this court, on the basis of the undertaking filed by the alleged contemner, has directed the alleged contemner to pay rupees 8 crore, being the full and final settlement, out of which the contemner shall pay rupees 1.5 crore, being the first installment on or before 30th November 2023, and the balance amount shall be paid in 7 installments of rupees 1 crore each of 6 installments, and 7 installments shall be rupees 50 lakhs, and the said installment shall be paid on or before 30th of each succeeding month. It is the case of the petitioners that the alleged contemner has not paid the amount as per the guidelines set by this court. And as such, in terms of the order passed by this court, the petitioner is entitled to the alleged contemner is liable to pay interest. If you want to sell the counsel for the petitioner has handed over the calculation sheet and submits that though the petitioner has received the amount of rupees 8 crore along with interest at the rate of interest of rupees 1 crore 51 lakh 25,000, but an amount of rupees 78,94,709 is still pending, being the interest at the rate of 18%. Had the learned counsel for the respective parties perused the materials on record, this court find that the alleged contemners have paid the total amount of 8 crore. Other than the 8 crore rupees, the alleged contemner also paid rupees 1 crore 51 lakh 25,000. Full stop. In view of the above, this court find that the petitioner has already received principal amount as well as the interest of rupees 1 crore 51 lakh 25,000. Thus, this court did not want, and this court is of the view nothing survive in the present contempt application. Accordingly, contempt application rule, if any, is issued against the alleged contemner is discharged.
And the interim orders would stand.
Fully.
Because there's some orders on restraint with regard to the property.
The interim discharge, all interim order passed in the proceeding is.
But only one thing, the receiver was appointed, he was paid remuneration of 3 lakhs and all, and the other costs. So, my lord, what's the cost? That is what my client was already saying, that my lord, some amount. The receiver was appointed, who was paid 3 lakhs.
That is to be paid.
Lord, I have paid 1 crore 51.
No. I have to dispose of the on marriage.
I will pay, my lord. I will pay.
I will pay. During the pendency of the contempt proceedings, the court has appointed the receiver, and the remuneration of the receiver of rupees 3 lakhs.
3 lakhs
has been paid by the petitioner. Full stop. As the contempt proceeding has been disposed of, according the petitioner is directed to the alleged contempt number 4 is directed to pay rupees 3 lakhs to the petitioner within a week.
7 days, no.
Within a week from date.
Alleged contemner or the person paying? I mean, really.
Lord, we will pay the money, my lord. Once we have paid this much, 3 lakhs will not stop. Lord, only one humble request, my lord. Lord, the statement may come, they will withdraw the suit also, my lord. I have made the payment now.
I am appealing for 5, 6, 7, and 8, Lordship.
This was the
it is submitted by the parties as
once the 3 lakhs is made, we shall.
As per the agreement, as per the settlement arrived between the parties, the alleged contemner has paid the total amount along with the interest. Thus, nothing remains in the suit. Accordingly, suit being so and so is also disposed of.
Great, very great.
To oblige, Lordship.
Much obliged.
What is the GA? What is the GA? What is your GA? GA is already GA is according disposed. Yes.
I was requesting Mr. Bose to file his notes of argument, because this is now over.
I will pass the judgment.
That's what I'm saying. He has the notes in his hand.
If your lordship recollects on, I was correcting the notes. 28th of January, your lordship gave me 10 minutes time. Judicial order. So today, is it my fault? If the bar takes a resolution.
I'm only saying lordship has heard Mr.
That's why, that's why I have prepared the note.
Come on Monday.
Very.
Let it same position.
Yes.
Give the fact.
22, 23 and 24.
In 23, my lord, I am for the successful bidder, my lord, no copies, half, my lord, upon my.
Item number?
By email.
Item number?
Kindly direct my land to sir.
और एक ही है?
I am appearing on
Copy down.
number 22.
22.
Now, my lord, 22, 23 and 24.
Yes.
My lord, by the clock 2 minutes. In 24, according to me, 22 and 23, I have a difficult case. Why? You know, a tender was floated. I am indicating it to your lordship. You know, tender was
23.
Bhai, a tender was floated for various items. A person, you know, the private respondent apparently is ineligible to participate. He has been allowed to participate and he has been shown, you know, as a successful bidder in the pre-bid of this technical bid. In respect of items for which I did not participate. In the notice inviting tender, you know, the pleading in the writ petition is otherwise. I am indicating it to your lordship. Now, my lord, be that as it may, my only challenge is, my lord, the selection of the private respondent, my lord, insofar as his eligibility, he is inherently ineligible. Why? My lord, because, my lord, kindly see
number 21.
22.
22.
22, I appear on behalf of the state. My lord.
My lord, 5270.
22 private, you are the private respondent.
23.
Not private. Yes.
Now, this is my affidavit of service.
Yes, which
My
document?
lord, I just give me, my lord, page 26 is the notice inviting tender.
Page
26.
Yes, 26 notice inviting.
Is the notice inviting tender, my lord, the items are listed. My lord,
Page 70.
page 70.
Yes.
My lord, page 70 is the bid summary. My lord, 19/12/2025.
Correct.
My lord, your lordship will be pleased to find.
70, 72.
My lord, at page 70.
Number 1.
Number 1.
Number 2.
My lord, this number 1 is, my lord, human diagnostic surgichem. Surgichem. My lord, number 1, he has been named as a bidder, my lord, for making him eligible for financial bid to be opened. Now, my lord, what we are on is essentially
70, 72, 80, 81, 83, 87.
Yes.
Is the private respondent?
Yes.
Is the private respondent?
Yes. My lord, 70, his name finds place, my lord, at page 72, at pages 80, 81, 83, and 87 in respect of various items.
Correct.
Various items. Now, my lord, what we are on is, my lord, please see page 31.
31.
Yes.
Page 28. 28.
My lord, the eligibility criteria is at page 28.
Who are eligible?
My lord, he has to have a distributor.
Agent.
Who are not.
My lord, only manufacturers or direct importers capable of supplying the quantities as per requirement.
Where
My lord, page 28.
Yes.
As per requirement given in table 1 and having commensurate annual turnover as per clause 8 of this bid document would be eligible to quote annual turnover, etc. You know, distributors, agents, contract manufacturers are not eligible.
So who will be eligible?
Only manufacturers or direct importers. It's indicated at page just below 8. Just below 8. Paragraph 8, eligibility for quoting.
Only manufacturer or direct importer.
Yes. Now, here, page 88. Page 88 would show, that he is a distributor.
88.
Yes. 88.
Wholesale, drug and
But he is a wholesale in original unopened packages. He is a wholesale distributor on the right hand side. It's a license mirror under the drugs and cosmetics rules. Human diagnostics. Now, making him eligible. Making this firm eligible for financial bid opening and subsequently making an endeavor to award the contract and enter into agreements with him, that we are questioning. That is subject matter of item number 1. In item number the next matter is where persons ought to have furnished certain details. That details has apparently not been furnished according to us. And it is an inherent lack. Please come to the qualification clause. Please, the tender begins at page 29.
Before my same tender.
My lord, before my learned friend, my lord, takes your lordship to the tender and other documents in the petition, my lord, I apply for the state in that matter, my lord.
Which one?
23, the matter which is now being placed before your lordships. My lord, I plead before your lordships to consider whether an action impugned in the petition is of 19th January. Since then, till yesterday, they sat back, did nothing. Not a single pleading of urgency, even stating that there is an urgency in the matter is concerned, has been given in the petition. In these circumstances, my lord, the state advocates and the my lord, officers have been burdened, my lord, to come with this. My lord, I am sure, my lord, it was not brought to your lordship's notice. Not a single sentence on what have prevented them since 19th of January, which is the impugned notice. They did not take any step, no explanation. They have not even stated that there is some urgency. My lord, I stand to be corrected by my learned friend, my lord, for the petitioners.
Just now I received the copy. My lord, kindly take it Monday, my lord, so that I can satisfy your lordship, my lord.
May not be necessary also.
Yes. After 1 month, you filed the 27th February, you filed
this tender. I have written a representation at page,
January.
Of January.
Which is before
we have expected them to give a decision, as to
whether the tender work order is issued.
Yes. Work is going on, work order is issued. Long back in
Work order is not yet issued, according to my instruction.
Work order has been issued.
9th of February.
Till 9th. Agreement completed, my lord.
9th of February, it has been done. The last date of giving it was 10th February. Before that, it was given.
Let them file a affidavit report by one affidavit. I am fixing on Wednesday.
This matter, 23. Very well.
22
my lord. The 22
kindly.
Not been issued. They are working, my lord. So far as the 22 is concerned, my work order has already been issued and they have been working, my lord. They have been working. And not only that, these are all blown drugs, my lord, items. So there is no requirement of my lord having license of drug license and or GMP or GLP certificate.
No,
as a specific case.
No, their case is that their specific case as per the tender document, only the manufacturer or kindly come to only manufacturer or direct importers.
I shall satisfy your lordship.
Page 28, only manufacturer or direct importers. And the distributor, agent, the contract manufacturer not eligible.
Well, there are other criteria also, my lord. My lord, I shall satisfy to your lordship.
Things before your lordship, my lord, passes this order, not on merits, but on my lord. It has been persistently held by your lordships as also the Honorable Supreme Court that to dislodge a person, one must show that he will be taken into the fray of consideration. For that, he needs to make out a case, at least state that he is a L2 bidder.
That's why.
There is no statement. Now, my lord, I find myself at a loss. How, my lord, the petitioners will not even say that they will be able to maintain this cause without even asserting that if the private respondent is dislodged, then they will be taken into consideration. In that even, I will
from the state.
Yes.
Prove one thing. Just give me one. I'll stop. The opposition is, work order has been issued. We have come late, according to them. 19th of September is the tender. 5th of January is the representation. What is happening? I'm indicating in item number 23. There was a previous clause, that persons who were awarded contracts who did not execute the contract would be
completely debarred. Despite that, they have allowed the private respondent not only to participate, but had in, and what had happened, he has been blacklisted. There are documents here. Kindly see, if I am incorrect.
We can move into
whether you have
minutes. Yes.
participated.
Yes.
What is your position in the tender?
I am also eligible.
Well, no, eligible. What is after the
The financial bid has not been opened.
This is beyond pleadings. Beyond pleadings. They have not made out this case. We can answer on merits if your lordship so wishes.
Item number 23.
23, there is not a single pleading that they are L2 bidders or they will be considered if they can.
Just I'll answer Mr. Post. Just give me 2 minutes.
Participation pleaded.
Please,
Nothing else pleaded.
please see. This is what was uploaded at page 70.
Pleading.
19th December 2025.
হ্যাঁ দাদা তুমি ঠিক দেখছো কি
Just give me
78 মনে হয় item number 20 page 78 হবে
Oh, sorry.
No, whether
Page 78.
of WPA
5273, my lord.
5273.
5273.
5273.
My case is, in 5273, the private respondent is.
That is correct. That whether you have
Now,
participated.
Greenco has been blacklisted. Greenco has been blacklisted. That document is also here.
Page 76.
Page 76 is the blacklisting document. And what is the reason for blacklisting? Kindly see. Circular. 14th October 2025, there is post-tender. Whereas Greenco state-based such and such for supplying such and such for a period of 2 years from the date of issuance of contract. Tender dated is 10, whereas Greenco became L1 bidder for supplying the item such and such in the tender number this. Whereas Greenco declined to accept L1 on the pretext of quoting the wrong rate, whereas refusal to accept the selected L1 rate quoted by the bidder himself with the excuse of quoting wrong rate and vitiating the tender process is liable to be punished as per TNC. Whereas a notice for personal appearance, etc. And whereas the said drug is very important, ultimately 3 years debarment page 77. And this person has been, at page 78.
Read the whole sentence. Read that whole sentence. Read that whole sentence once. The last sentence. Debarment is for only the items mentioned for 3 years.
Yes.
And my lord matches, those items are not there in page 78 or 79.
You mentioned 3 items.
But 3 years.
2 items for 3 years. Yes.
For the
Right.
for 3 years.
Yes.
I take it, for
Page 33.
then, kindly falls back to page 33, the eligibility criteria.
ওখানেও একই লিখেছে। But these questions will be relevant if they show that they will be considered.
Paragraph 9. Roman 2, paragraph 9. The bidders who were declared blacklisted by any such and such in the country as a whole for any items quoted are not eligible to participate. I put this question to myself, Mr. My learned friend. He is inviting your attention to page 77, saying that only for the item what the tender condition is otherwise. Tender condition is other. Maybe I am incorrect.
Read the whole.
Bidder who were declared blacklisted government health institution in the country as a whole or for any items quoted in this tender.
Yes.
In this tender.
Not eligible.
Correct. In this tender. Whether
Tender as a whole.
correct. Or.
Yes.
Item or item.
Items.
As a whole or for the item or items, according to.
No, within bracket quoted in this tender.
Yes.
Are not eligible.
Gratefully.
So this tender, this materials, this articles are covered under that debarred order.
My humble submission is, this Greenco, in view of this clause 9(2), could not have been allowed to participate in the tender at all, because he has been admittedly, on 14th of October for items maybe blacklisted, but as a whole he could not have participated. That is my, I may be incorrect. Clause 1 is also of.
Yes, and these will be available to the petitioners in case they can show or say that they were L2 bidders. They have not said it.
What about
Who are they?
your position?
My position, I am also eligible.
Not a single pleading.
Page 78 of
Page 78 of the writ petition.
There is not a single pleading.
May I just add to what Mr. Bose is saying, there are 6 petitioners there. 6 separate bidders who ought to have competing interests with each other.
Yes.
They have some reason unknown, they have come together and filed the writ petitions, before your lordship.
Their cause of access.
Now, the question is, That my lord, first of all, my lord, they are seeking debarment
He's also
of the other
for
person.
70.
I am in 24.
No, 24.
24, I have not argued
No,
24.
I am just on
No,
the
you
point.
can't argue 24. I have not argued
You are
24.
joining same issues, my lord.
No, the 24 is a
Then let them show their eligibility from the pleadings at least.
Things cannot
Where you applied for, what is the condition, where is the situation?
others cannot.
Where is the situation?
They have applied, they have said, they have been placed as L2 or by dislodging the private respondent, they will be considered, they have not made out that case even. But I stand to be corrected by my learned senior colleague.
Writ petition number 52, if my lord takes up 5273 writ petition. The writ petition 5273.
Yes, I am there only.
ওটাই ওটাই দেখাচ্ছে, ওটাই দেখাচ্ছে।
এই যে
70 it is not pleadings.
No, where is my name? 82. You know, I am
For a different thing. This is the final list. I do not know what they are trying to show.
Cannot be L2, all six cannot.
The list of L2 has not been annexed. They have not pleaded also.
Milord, I am not the list of L1 and L2 is not been told.
Okay, no problem, no problem. In all three matters, I direct the state authorities to file their report by way of an affidavit by 10th after serving the copy, and matter be taken on 11th.
Lord, we can come back with the report, but I was, Lord, really urging your lordships to settle this point, whether by not showing that they will be considered.
That's why you bring all these things. Who has participated? How many tenderers have been participated? Who are the L1?
That Lord, I will come, but that Lord will deposit of respect will be, Lord, initiating a roving inquiry at the instance of the petitioner who has not been able to show or even say before this court.
That's why I will decide this.
And my Lord, last thing, last one thing, I will not press it much, but just to bring it to the notice of your lordships, my Lord will kindly take up 5273. Probably your lordship is looking through that. My Lord will kindly take up the my Lord name of the second petitioner, Shukanto Das. Shukanto Das is a nobody. Kindly seize the cause title once. Shukanto Das is the constituted attorney of the sole proprietors. So the sole proprietors who had allegedly participated in the tender, my Lord, appoints a constituted attorney, and the constituted attorney comes and sues in his own name. First, second thing, he could not have 6. Second thing, my Lord, second thing, the constituted attorney, if not specifically given this power, cannot appoint any other person to plead, to affirm pleadings, which is the petitioner number 1.
How 6 persons has come?
This is fraught with
Same thing as they are the syndicates. They are the syndicates.
Yes.
They cannot have common grievance because they are competing with each other.
Yes. They could not have joined.
Yes.
Fraught with, my Lord, I do not know what, my Lord.
Okay.
We are questioning essentially the eligibility of the private respondent.
Okay, let
in the third petition, there is a completely different story.
The petitioner has challenged the tender process initiated by the authorities. The counsel for the respondents as well as the private respondent submits that tender process is completed. The order has already been issued. In view of the above, the authorities are directed to file a reply by way of an affidavit by 10th of March 2026 after serving the copy to the learned counsel for the petitioner. Let the matter appear 11th of March 2026 under the heading urgent motion within 3 matters.
In the third matter, there is an issue. When we point out this, now they have floated a re-tender in respect of items for which, my lord, the private respondent is apparently on the face of it debarred. That I can persuade your lordship here and now. My lord, just takes, my lord, once, my lord, with folded hands. My lord, kindly takes the third item once. 11 February 2026, they have page 100. Page 100. You know, is the re-tender in respect of re-tender in respect of item number 16 at page 119. This is a re-tender and it is in respect of 119. Where the essential requirement in 16, serial number 16. This is the item here. Admittedly, we were in the fray. That would appear from the bit summary. Page 78. 8.
No, 119, item number 16.
That is the re-tender once again.
Where is the re-tender? Where is the
Page-
re-tender?
page
100 starts.
Page 100. Re-tender is hereby invited on behalf of the Health and Family Welfare Department, Government of West Bengal, to prepare a rate schedule of supply of listed items for a period of 2 years from the date of issuance of first approval notice award of contract
Correct.
and its extension. This is re-tender. Now, the first tender.
That is 11th February.
Yes.
Yes.
Now, this is, apropos the first tender, which is at page 30.
And the relevant portion is page 50.
Page 30.
30 is the first tender, the same tender, 19 September 25. There, the list of items.
Let me see the page 30. Where?
Page 30.
Yes.
Now, the relevant portion.
Where is the item?
Yes. The
page 30?
list of items.
Page 50.
Is at page 50.
Starts at page 49. List of items starts at page 49.
50.
50.
Item number 30.
30. Item number 30.
Item number 30.
Correct.
Now, this ultimately at page 78. Your lordship will be pleased to find at page 79. Serial number 30 is the listed item, who are eligible.
Page number 79.
79. 30 is the concerned number, the item. And your lordship will please to find Krishna Pharma's name. Krishna Pharma.
Yes.
Now, Krishna Pharma is the private respondent here. Now, Krishna Pharma is respondent number 4, and our names figure, against, associated chemicals, chemicals, PH Laboratory, Overseas Chemicals. We are all the petitioners here. We are also, eligible for financial bid opening. Now, when we point out this, by our representation at page 97, 5th January 2026.
Then the page 50 is the first tender.
First tender.
Correct.
Serial number 30 is the item.
Number 30 is the item.
And which, 90.
And the retender is 119.
Retender is apropos my representation at page 97. They, what we point out is kindly see, just 1 second, are allowed to participate only for those items where the separable capacity is etc. is more than one. One of the eligibility clause is this 120% of the estimated amount. But the bidder Krishna Pharma has declared the sparable capacity for all items in the tender as 100%, but the declaration is totally wrong. And disinfectant, another issue. This BIS certificate, third line requirement was BIS certificate, which he did not produce. So, when we point this out, they immediately float a fresh tender instead of, restricting the process by ignoring Krishna and giving it, opening the financial bid, excluding Krishna. They once again re-tender it, and, at serial number 15 is the same item once again.
The relevant pages are page 92
and 92 and 93 are the relevant
92,
pages.
93, 94, 95.
That is the sum and substance. So, this petition, if they say that 11th of February has also reached finality by today, then perhaps, I really don't have a case, because I persuaded your lordship in respect of 24 that they are likely to award the work order on 9th. That is the issue. That is the issue.
Who don't have it only for we have not taken one party. Asking for blacklisting of the private party. But the question the state court is always cannot be used as a sword to only dislodge another person. All 6 cannot be eligible. But they cannot all succeed. They are competing with each other. I do not how can my hand will come. Now, as far as 11th February is concerned, the representative just January versus the second tender which they are challenging is of 11th February. We are on 6th March. No representation in the meantime. What she goes under the rule 20 of the legal rules, they have to file a demand for justice. That has to be rejected. Then they have a cause of action before the government.
Yes.
This is the mandate of the law, but this is statutorily mandated, and the Supreme Court had number of judgments. Now, so I would have questioned myself, what is so urgent that they would come and the baggage of whatever timeline and they will certainly allege this. Instead of giving us an opportunity to deal with their grievance properly.
And what is your urgency to retender? What is your urgency to retender of the same item which was already there in the first tender?
Sir, I understand there might be some items that are overlapping.
So,
Not all. Not all.
not all, but overlapping. So you are giving the benefit twice to the contractor. If it is overlapping, not 22.
24 is going on. 22, 23.
So why overlapping? This kindly come to the 119 and kindly come to the 50. So if it is there and you are telling that is the work order has been issued, the why the retender of the same item? And what is the necessity of the issuance of the retender?
This work order has not been issued, Milord. That is what prompted me to bring it to your lordship's notice.
9th of March. Where is the bid? Where is the tender, that timeline? Where is the timeline of the retender notice? Correct.
So the bid is opening on technical side on 9th of March.
117.
Finalized immediately.
117.
117, my lord, kindly keep on the dates and information there.
Yes.
My lord, point number 7.
Hmm.
My lord, bid opening date is 9th of March 2026.
Technical bid.
Yes, my lord, so nothing is happening just in the next week, my lord, let me come back. Just the opening of the bid, it is not closing, and my lord, the date of uploading item for bid summary, these are notified yet. My lord, nothing is happening.
You know, 9th March, what initial submission was, everything is done. Now when confronted,
not this.
Now when confronted, Milord, Mr. Dotto also made that submission. When confronted now, Milord, maintainability, Milord, I am again repeating. And Milord, insofar as demand for justice, Milord, this has not seen the finality by saying is.
See, I am fixing on 11th. You come also with the affidavit on the report. Same order also. With regard to the item number 22 and 23. 24, no. 24 record. The last date of the opening of tender is 9th March 2026.
My lord, only one request, my lord. Only one request, if you may make, my lord. 23, my lord, instead of 11, let it be on 13, my lord. Because we have already bond our mean title land beyond.
Please see, no work order should be issued in
the technical, my lord, then the financial.
That's why whatever I am not staying the proceeding, but see work order should not be.
And
I am fixing on 13th.
Back before your lordship before that.
19th, 13th period.
And my lord, the question of maintainability, my lord, kindly be kept open.
Question of maintainability, my lord, will make. At the instance of tenderers cannot come. That is what you are telling me.
Huh? No.
Mr. Bose, tenderers cannot.
My lord, the maintainability may kindly be kept open.
Kept
open. My lord, yes.
Maintainability of maintainability.
Lord, whatever I am submitting, my lord, has flown from Mr. Bhattacharya only in previous matters. Of course.
Sometimes, my lord, the view of the learned advocate is different from what the learned advocate is submitting.
My lord, 7 my lord. Because if we go to the sunlight, then automatically color change.
My lord, my lord.
My lord, item number 47, my lord. Thank you.